Please, your lords.
Yes.
My lord, I have filed an urgent writ petition today, my lord. Matter relates to the appointment of mathematics teacher, graduate teacher mathematics, my lord. What happened on 19th of this month, my lord? They were rejected on the ground that some prescription has been made after the advertisement by an addendum in the qualification. The physics subject is required. So on 10th of October, the appointment will be centralized appointment will be issued. So, my lord, I pray the matter will be taken day after tomorrow. Very urgent, otherwise, my lord. And other two petitions with the three
All motion matters.
on two motions, two admission.
Admission matters will we have to take it up.
Here in this case, my lord, same matter, my lord. Interim order is there, but they are not complying with the interim order. They are holding up their candidacy. So, if my lord, since interim order is there, one post is not reserved, my lord, then my lord,
There's an interim order, so what is there to worry about?
no, they are not, my lord, complying with the interim order. The interim order speaks that their candidates shall not be rejected on the basis of that addendum, prescription of the addendum. But what they are doing now on 19th, they held up their candidacy. That is why, my lord, urgency.
So then you have to file appropriate process. What will happen in the admission matter?
Then motion only, man.
You have to take
motion.
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 Item number 33, my lord. Can it be taken after the 50%? My instructions are awaited immediately after the reopening. Item 33.
The Bora?
Yes, I'm
On
a
15, well,
on 15.
15, 10,
15.
regarding my lord,
What is the
registration of
position?
farmers with
What is the position 15th?
Well,
Wednesday.
some urgency is there.
All right.
15.
The big over on it. Council. Is item number
30.
30. On it, Standing Council Health Department suffice that he needs some time to get in touch with the matter. And please that the matter be listed on 15th of October. So the pay is not objective to the President Board on that. Take the matter of 15th of
15 October. March. Item number 4 is part of 43.
Or is passed over for the day.
After the week.
To be listed. Okay, as paid for by the learned counsel for the petitioner, Mr. P.J. Cycle, let the matter again after the week without taking.
Apply.
May be Lordship, I beg to mention for listing a motion made at tomorrow, my lord.
Have you filed it?
Lordship, tomorrow?
Did you file?
Yes, sir.
When did you file?
20.
20.
20.
What is the urgency?
Urgency is the selection list was published by the BTC authority, master. Lordship, they have published the selection list for only for the BTC candidate who are belong to BTC.
All right, all right. This is a motion week, so we'll allow you.
Motion made.
This is a motion week.
Lordship.
This week is a motion week. As you are aware, before pujas, normally 1 week prior to the holidays are motion week. That's why I'm allowing you tomorrow. Okay,
Yeah.
next. Huh? You have not understood.
Tomorrow.
Tomorrow,
Lordship.
that's what I'm saying.
Okay.
Yes.
I got similar prayer, my lord. Coupon matter, my lord. Day after tomorrow.
Have you filed?
Yes, my lord.
When did you file?
20, my lord.
On 20. Urgency is there? Okay,
What I'm praying for listing of a matter tomorrow for withdrawal, your lordship,
okay.
and another on 16th, your lord.
For
Admission, your lordship, one similar matter is fixed on that.
16, you take it up, admission matter, you take it up with the registry.
But lordship, one similar matter is fixed, lordship. Similar matter, lord. That is why I'm praying for.
That's why you take it up. We'll see.
May I please?
Hmm.
Alert, I beg to mention for listing in motion.
Motion,
Motion.
new case.
New case.
When?
Alert, item
Friday. Okay.
most of it.
My lord, I'm praying for listing it. Withdrawal matter tomorrow.
Okay.
Lordship, I beg to mention for admission, lordship,
Admission don't mention. You go before the registry and
the problem is that on 10th of October, they will be published, finalize the grade for appointment clock. And
so
the petition filed on 24 logic. This matter was came before the Honorable Court on 18/9 logic. But on the day the court was not sitting, and yesterday also this matter came for admission also. But
It was the,
Yesterday as item number,
yesterday item number.
give me the item number. Mr. Padgiri, any mention?
Item number 35, madam.
35.
So that it is a contempt matter order already complied with.
You are for the petitioner.
Petitioner, madam. Item 35.
The item 35, please write, Mr. K.R. Padgiri, learned counsel for the petitioner, submits that the order of the court has already been complied with. Mr. Pinji of above, the contempt petition stands closed.
Another, madam, item 37, my lord.
Hmm.
So it is the bench fee matter, my lord, wrongly listed before this.
Item 37, please write, Mr. K.R. Padgiri, learned counsel for the petitioner, submits that the matter is a bench tree matter and has been wrongly listed. Stop registry to verify and list accordingly before the appropriate bench.
Oblige.
Yes.
My matter was listed on 23rd September.
Yesterday,
Yes, my lord.
Ah.
Holiday case was not heard. It is urgency to publication of selection list of teacher recruitment, my lord.
fishery,
Teacher recruitment.
oh, teacher.
Yes, my lord. So already
Item number yesterday,
yesterday, item number 21 before court number 9.
oh, before court number 9.
Yes, my lord.
Lordship, my matter was, before court number 2 yesterday, item number lordship, 24. Lordship, other is here because on 10, they will be publishing finalizing the approval of date for lordship. Item 24, court number 2, lordship.
Case number,
Case number lordship, WBC 108/202
of court number,
of court number 2, lordship. Yes, that is,
court number 2.
yes, sir.
What do you mean court number 2? Court number 2 is division bench.
Oh.
When do you want it?
Listed on my lord Friday.
Friday. Okay. All right.
Item 16 of court number 9, lord. Yes, sir. Sorry.
Court number 9. Okay, we'll have it on Friday.
Tomorrow, lordship,
Why? Why tomorrow? What is the urgency tomorrow?
because lordship on 16, there will be a lot of motion matters that file. At 2, lordship, or any,
Today also there is a lot of motion matters.
at 2 or after 2, at any point of time, it matter will be taken.
Okay, we'll have it tomorrow then.
May it please your lordship, the item number 30 may be passed over for
Passed over for
the day, your lordship.
30.
30.
Okay, 30 pass over for the day as paid for. Yes, next.
40, my lordship.
Hmm?
Concern of the other side. 40, item number 40.
40.
Concern of the other side, list the matter after vacation.
40.
40,
Okay, you are for the petitioner.
petition.
As paid for by the council for the petitioner. This is the matter again after the puja of the day. Yes, next.
Right, please your lordship.
Wait, one at a time.
I beg to mention item 18, lordship.
18.
Motion.
Yes.
Matter pertains to compassionate appointment, lordship. This is balance service period is less than 3 years.
Hmm.
So,
So what do
lordship,
you want?
matter may be taken up after vacation.
Okay.
Issue is pending before the division bench. lordship.
Item 18 as paid for by the council for the petitioner. List again after the vacation. All right.
Oblige.
Next.
I beg to mention item number
27. Yes.
The Indian conducting council, Mr. S. out of due to some problem. The English conducting council, essay since out of due to some problem. That may be other.
Have you taken the consent? Have you taken consent? Opposite party. You are to inform the other side.
I am for the respondent number 7.
I know. You are to inform the other side, take their consent. If we adjourn the matter today, if we adjourn it now, later on the petitioner will come and tell the court that my consent is not taken. How come? You take consent first. Do you know what I'm saying? One Mr. M. Ali R. Islam is for the petitioner. Speak to them. Say that we want to adjournment. If they have no objection, we'll adjourn it. You come again when the matter is called. Item 27. Yes,
This bracket, item number 12, kindly for the table, have the petitioner.
on the request of the learned counsel for the petitioner, matter stands adjourned for the day. Item 12.
Okay.
Yes, next.
The Lordship, I beg to mention item number 6, my lord. My
6.
lord, yes, my lord. My lord, my senior is now out of vacation, my lord.
Who? Mazhab here.
In his mother, my
When do you want it?
lord. After vacation, my lord.
Okay. As paid for by the learned counsel for the petitioner, let the matter be listed again after the entering puja application. Next.
Lordship, regarding item number 42 and 43, senior is unable to appear today because of his personal requirement. So kindly fix the matter after puja vacation.
Who is not here?
PJ Pukun, Lordship.
PJ Phukan. What happened?
Actually, he's actually not well,
He's not well.
suffering from cold fever.
Have you informed the other side?
Yes, Lordship.
The review is filed by whom?
I'm appearing for a respondent.
Any objection? What is this case? Review, first clarification, second clarification now. 3, 4, 5 clarification will come. What is happening?
They have filed the IF.
Okay, Mr. PJ Phukan, learned standing counsel, Guwahati University, appearing for the applicant is said to be indisposed. So upon a prayer made on his behalf and not objected to by the other side, list the matter again after the entering puja vacation.
Lordship,
Yes.
beg to mention, item number 19.
What do you want?
Lordship, adjourn the matter for today.
Why do you want adjournment?
Senior counsel is not present.
Who is that?
G. Bora.
On the prayer made on behalf of Mr. G. Bora, the matter stands adjourned for the day. Yes, next.
Mention item number 3, Lordship. May this matter may become after vacation, Lordship.
Okay, as paid for by the learned counsel for the petitioner. List the matter again after the entering vacation. Good job.
Here,
The one is for the petitioner is for the claiming is for retirement benefit. Yeah, and last occasion, they have take time for filing affidavit. But yet not there for filing an affidavit to me.
affidavit is ready, we will file matter. Some time is required, matter.
If it's ready, file it.
Some time is required.
Why are you hesitating?
We are
It is not ready, that's why.
annexure is. Annexure
If it's ready, you should have filed it. You have not filed it, that means it's not ready.
immediately after vacation.
Mr. P.K. Bora, learned standing counsel, Elementary Education Department, assures the court that he'll be filing the counter affidavit within the next 2 weeks. When? 2 weeks?
Month.
List again on so and so. Give a date. On 27/10.
Item number 2 is the same.
Same, similar order.
Apply.
Mr. B. Sharma appears for the Accountant General exam. Both cases, okay?
I think last occasion some instruction was sought for.
What is instruction?
Matter pertaining to arrears salary and graduate pay scale with other allowances, which amounts to 1,31,479 with effects from 91 to 1987 to 31/11/2007. In this regard, Your Lordship, DSC has wrote down the letter to Inspector of School Dhupri. So Your Lordship, instruction is awaited from Inspector of School Dhupri. So kindly matter may posted after vacation.
Date, my lord.
Ms. P. Das, learned standing counsel, Secondary Education Department, prays for further time to obtain instructions in the matter. As paid for, let the matter be listed again on survey.
I'm deeply obliged.
Head to the lordship.
Which order?
Page 12, my lord, paragraph 7 and 8.
Will you issue notice? No, but what has happened?
Thereafter, my lord, the inspector of school, my lord, forwarded the proposal to the deputy commissioner, my lord, to place the case. It was not placed. Page 15, my lord.
Any time frame was given by this court?
No, no, my
Page 15.
lord, page 15. The inspector of school, my lord, forwarded to the deputy commissioner for place, my lord, proposal. Now, deputy commissioner is sitting over the man. He is the chairman of the committee. And direction was to the deputy commissioner, my lord, for placing the case of the petition in the meeting for complete.
The only problem is that you've taken your own time to come to the court.
But we are, my lord, approaching, my lord. They are saying in the next meeting, they will place, my lord.
See, what you say and I say doesn't matter. The Act, Contempt of Courts Act said it has to be within 1 year. So how do you overcome that?
Under, my lord, Article 220, 215, my lord. Your lordship, my lord, limitation will be relaxed.
How limitation will be relaxed? Heard Mr.
Our element.
R. Ali, learned counsel for the petitioner, who submits that the order dated 29/2023 passed by this court in WPC number 242 of 2023 has not been complied with by the respondent, despite a copy of the same having been furnished. Stop. The learned counsel, referring to the letter dated 5/4/2024, bracket annexure 3, submits that the Inspector of Schools, BDC Bongaigaon, had informed the respondent had submitted a proposal for compassionate appointment of the petitioner against the available vacancy, but the respondent has not taken any steps. So hence, the petitioner has filed the instant contempt petition. Stop. The learned counsel, on being asked as to why the contempt petition has been filed after the period of limitation as prescribed by the Contempt of Courts Act under section. What is the section? (20), and to which he submits that under Article 215 of the Constitution of India, court has the power to take cognizance of the same despite the delay. Stop. Be that as it may, the same shall be considered at the appropriate time. Next para, issue notice to the respondent returnable by 4 weeks. Petitioner to take steps for service of notice upon the respondent by registered post with AD within 3 days.
All right. Easy on.
Yes.
This is a contempt case where the petitioner is a teacher. He's a teacher with over 32 years of experience at the Horulmukh
Show me the
LP
order,
school.
page
And
number.
The contemptor is the director of elementary education.
How many respondents?
One respondent.
Okay, where's the order?
The order, Your Honor, will find at page number 89.
39.
Actually, there are two orders.
Hmm.
The first one is at page 89. The last line,
Hmm.
till the next returnable date, no coercive steps to be taken against the petitioner.
Hmm.
So this is the first order that Your Honor may mark.
What is that coercive steps means? What does it mean?
So in this case, Your Honor, what had happened was we were being transferred. There was a show cause notice issued to me. Then under that show cause notice, they had passed a transfer order. We had put that transfer order to challenge in a writ petition. Now, in that writ petition, we had asked for the stay of the transfer petition, of the transfer, as well as this order was passed in that context, that no coercive steps to be taken. Meaning that what I read this to take this to mean is that all the cause of action that arose in the show cause notice cannot be agitated further. That is what I take it to mean. But now what happens is, Your Honor, that the moment this order now is passed, this order is served and is received by the opposite party, they issue a second show cause notice on the same cause of action. The same two letters, there are certain reports that they were relying on to say that I am creating some nuisance in the school. That is the general case there. So I had put it to challenge on certain ground. Now, the same show cause notice reflects again, is issued to me again. That Your Honor may find at page number 90, the next page.
Hmm.
Now, I may directly bring Your Honor to page 91 because this has the charges. Just 1 minute I'll take to read this.
No,
Your
Mr. Counsel, this is a contempt petition.
Yes, sir.
It is not a writ petition.
Yes, sir.
There's no question of having a hearing on the matter like
Not
that.
at all. Not at all.
So
I'm just
that's why we either issue notice on this or
Very
you
well,
file a
No, very
separate
well.
writ petition
No, that
challenging
is
Annexure 3.
agitating. I'm just showing that there are two court orders because Your Honor will ask why.
Where's
are
the
there
other
two-
one? Where's
Yes,
the other one?
Other court order, Your Honor, will find at page number 100 and page number 122.
120.
That's the second.
This is by in the IA.
Yes, Your Honor. There was an IA that was filed against the second show cause, not a contempt. An IA was filed. I'm just building the precedence here. And Your Honor may find the relevant paragraph at page 124. Your Honor has page 124.
Yes.
The last part. Having heard the submission made by the learned counsel for the petitioner, this court finds it appropriate that status quo be maintained till the next date of hearing. Now, this is where the second show cause notice. Now, in the face of this, they've gone and stopped my salary. That is what has actually triggered this contempt.
No, status quo. What is the second show cause notice you challenged?
Please, Your Honor.
The second show cause notice.
Yes, it's on the same cause of action as the earlier one.
What was this IA for?
IA was for quashing the second show cause notice.
11.825.
Yes, yes, Your Honor.
What you have shown me is that 11.825.
Yes, this is what we put to challenge in the IA. Now, there are two charges. I'll just very briefly. One charge is on the exact same show cause notice as earlier, and the second one is for my not joining the transferred post, which we say was stayed.
Okay. Now, after this status quo, what have they done?
They have stopped my salary for the month.
Where is the statement?
Please, Your Honor.
Your statement?
Statement is not there, Your Honor.
Then how do we
But we
accept
made
you?
the submission to this effect.
Huh?
We put it on oath that they have stopped the salary, and we wrote a letter also.
No, there has to be a statement in your contempt petition that my salary has been stopped.
Your Honor may have Annexure 11.
Lecture 11. Page?
Page 131. Because we issued this letter to them. Media. So this is the letter that I issued to them, clearly saying that my salary has been stopped.
What is the date?
The date of this letter will find on the next page, Your Honor, which is the delivery receipt I've attached. So it was issued on 8th of September at page 13. Page 132.
130?
132. Item bag 8th. That is when this letter was couriered.
Item bag. The first one.
And it, yes.
The first one.
Please, Your Honor.
Page 132. Where is the date?
The date, Your Honor, is item bag. If Your Honor will see
Item
the
bag.
first one.
The first one.
Yes. Item bag. So that-
Dated?
And then it is delivered on 10th of September at the last column. So we issue this letter to them. And Your Honor, may I also have paragraph 13 of my petition, of my page number 8. Para 13 is the last paragraph.
No, this is what I was asking you. Whether
is
you have made,
submitted.
whether you had made any statement.
The
So you-
statement is not on record, but I have put that there.
It's not on record. What do you mean? Paragraph 13.
The statement is here, para 13.
That's what I was asking
Okay,
you. Where is
got
the
it.
statement
Okay.
to that
I thought
effect?
Your Honor was
So
referring
that
to
was
the bank statement.
sufficient.
Yes.
Anyway, I heard Mr.
D. Das, Your Honor.
D. Das, learned counsel for the petitioner, who submits that the respondent authorities, having failed to comply with the court's order dated 8/1/2025, passed in WPC number 28 of 2025, and also the subsequent
21/8.
order dated 21/8/2025 in IAC number 2755 of 2025, has filed the instant contempt petition. To stop, he submits that the petitioner was put to transfer, and which was challenged by him in the writ petition. To stop, this court, by order dated 8/1/2025, ordered that no coercive steps should be taken against the petitioner. Stop, despite the same, a second show cause notice was issued to him, and for which the petitioner secured a status quo order from this court on 21/8/2025 in IA C number 2755 of 2025. So despite the same, the salary of the petition has been stopped by the respondent. Stop. As such, the petition is before this court through this contempt petition. If you notice, returnable by 4 weeks.
Your Honor, I have two small further submissions. First is this order may be given dusty, so I may serve it on them in the interest of time. And second, Your Honor may consider directing them to purge the contempt, so that at least the violation stops. They can take the defense once they receive the notice what the situation is, but no
No.
procedure has been followed and it's completely been stopped.
No,
think
we'll
they should-
see, we'll see on the returnable date. Make it 3 weeks. Petitioner is given liberty to serve the respondent, sole respondent by way of dusty, which should be done through the registry of this court within a period of 10 days from today. Upon serving notice by dusty, the petitioner shall file an affidavit as proof of service. List the matter again on so and so.
Your Honor, one line on purging the contempt, if Your Honor may consider.
No, October
13,
30 October.
please. Your Honor, consider purging the contempt, one line on that, so that at least my salary gets released. Otherwise, I'm in a very difficult spot.
So you serve them to stay.
I will serve them.
They'll be out.
Deep privilege.
Material. My lord, in this case, my lord, I am praying, my lord, at this stage, my lord, notice may be issued.
What is your case?
Well, case is that, my lordship, kindly have a look, page 17, annexure 4. As per this office memorandum dated 1st June 2015, my lord, if, my lord,
Page number?
page number 17, annexure 4. Here, my lord, as per this office memorandum, if, my lord, any employee dies in service, my lord, his, my lord, dependent may be appointed, my lord, on compassionate ground, my lord. Subject to other condition, my lord.
This is for appointment on compassionate ground, my lord. Now, my lord, the petitioner is aggrieved by the subsequent, my lord, office memorandum.
This is different from the usual compassionate appointment.
No, my lord, this is
This is the scheme.
this is last, my lord, guideline for compassionate appointment.
The compassionate appointment has been stopped
Stop, my lord.
because of the compassionate pension scheme.
Yes, my lord. He is agreed by this scheme, my lord, page 25, my lord. Page 25, my lord, as per, my lord, the relevant portion of the page 26, clause, my lord, 5.11.
Yes.
5.11, my lord, this provides that, my lord, the scheme is applicable to those employee who dies, sir, my lord, 1/4/2017. However, the relevant office memoranda related to compassionate appointments such as so on or before 31/3/2017. So, my lord, for compassionate appointment, the deceased employee should have died, my lord, before 31/3/2017. Therefore, my lord, he is not getting compassionate appointment.
When did the person die?
He is died, my lord, on, my lord, 15/4/2017.
15/4.
Yes, sir.
Then he's not eligible.
Not eligible.
So
Therefore, my lord, he is against this clause, my lord.
you are challenging this.
Yes.
Annexure 5.
Annexure 5, clause 5.11, my lord.
5.11, isn't it?
Yes, sir.
You're challenging this.
Yes, sir.
Yeah, so in this case, our negative fixed method is not a party here. We have filed one IA minor, NCPIA.
Who has filed IA?
Let's to then. Thank you. What is it?
Yes.
Oh. Okay. The deputy engineer, what did it?
So, first respondent.
NCPIA.
But IA is already disposed of.
No, how do we know it's bench 3 or non-bench 2?
But this attack, my lord, perhaps pertaining to the bench 3, my lord.
You also admit. Petitioner, Water Resource Department.
Yes.
ma'am.
Oh.
Yes.
He's right. He's submitted at the bar that the matter pertains to a bench 3. Registry to verify and list according.
What?
Now, relevant photo cover. Keep the blood.
I can put.
Yes, what happened to that microphone? Why is it down like that? In front of you, that microphone? You know, microphone like this. This is microphone. Working? Okay. Is it not similar with that, the other one?
Other one.
No, the other one is like this. And this one is what? This is different.
Not
Oh, okay. Okay. Yes, what were you saying? Yes. So, what do you want to say? Hmm? He's not present. I can see he's not present. You are not Mr. Tutia. None appears for the petitioner when the matter is called. Office note dated 4/8/2025 indicates that the application for correction of the cost title has not been received by the section till date. Under the circumstance, the petitioner shall do the needful. List again after the applicability. Miss, your good name? Hmm? P. Devi. Learned counsel appears on behalf of Mr. T.C. Sutia, who represents respondent number 4.
Please, Lordship, my lord. My lord, petitioners are my school mother teacher, whose salary has not been paid, my lord, since 2014.
Since 2002.
2014.
2004.
Yes.
So,
They were appointed, my lord, as a school mother teacher in 1998, 97, 98. The salary, fixed pay, my lord, 900, 500, my lord, has not been paid till now.
so this writ petition is basically for payment of the salary
Yes, ma'am.
since 13/11.
13, yes, 2004.
What is their response?
At Moses State.
Oh, this is a motion stage.
Yes, ma'am.
But some additional affidavit was to be filed. What was
Fine,
that?
yes, ma'am. Regarding some, my lord, some orders of this court, my lord. In
Please
a
write,
yes, ma'am.
in terms of the last court's order dated 14/7/2025, the petitioner has filed the additional affidavit. Well, you put one more date in terms of the court's orders as dated 4/6/25 and 14/7/25. Next para, Hart, Mr. Your good name? Your good name?
R.S. Chauhan.
R.S. Chauhan,
Chauhan.
learned counsel for the petitioners, who submits that by filing this writ petition, the petitioners have sought for a direction to the respondent authorities to release the aerial salary of the petitioners which has been pending since 13/11/2024. He submits that the petitioners have been recruited and appointed as mother teacher. Where?
97, 98, my.
In the year 1997-98. In which school? Where?
Different.
In different schools under the BTAD. Next para, issue notice of motion returnable by 4 weeks. Mr. N. Bora, Lanet, Standing Council. PTC.
Number 4, 5, and 6.
Accept notice on behalf of respondent numbers 4, 5, and 6. Petitioner to take step for service of notice upon the respondent number. No. 4, 5, and 6, isn't it?
4, 5, and 6.
Okay, then you write, who's appearing? State? Ms. R.M. Borua, Learned Standing Council. Finance appears and accept notice on behalf of respondent numbers. Respondent number 7. Your good name? Ms. A. Das, Learned Council appears for respondent numbers 2 and 3. 2 and 3.
1.
Let's go on for respondent number 1. One only.
R for response number 8.30.
Huh?
For 8, response number 8.
Who?
The standing council of WPT department and BC department.
Who's that?
Ardhar.
Ardhar. Mr. Ardhar appears accepts notice on behalf of respondent number 8. Please inform him.
Yes.
Petitioners, the notice is therefore complete. Stop petitioners to serve requisite copies of the writ petition to the learned counsel appearing for the respondent today within 2 days. List again after COVID.
Obliged.
May I please request if kindly pass over the matter for the typing. If Mr. P. Datta is on deck, then put up a one.
Time being.
Much obliged, sir.
Lottery 15 and 16 lottery may kindly take up after sometime. Education is only in number 1 lottery. 15 and 16 both items.
Okay.
He owns 3 crores. One of
May please welcome. Lord, this is a covered case matter. What happened, Malad, the petitioners, Malad, are working, Malad, as Rateco employees in the various, Malad, AMI schools.
In this school.
AMI schools.
ME school.
Yes, ma'am. AMI schools, Malad. What had happened, Malad?
What is the full form of ME?
Malad, Middle English. Middle English.
Middle English school.
Yes. What happened under the 2018 Act, Malad, of the provincialization, Malad, they were supposed to get fixed pay, Malad. The provision is for fixed pay. Lord, you will find that, Malad.
Hmm.
At page 95, sorry, Milad, 98, Milad. This is the Act, Milad, I have Milad enclosed, Milad. The next, it starts from page 92 and page 98, Milad, is a relevant provision, Milad. Milad, section 662. Those teaching staff whose services have been provincialized under this Act shall get a fixed pay as specified in the schedule with effect from the date of the provincialization of services. Now, this was put to challenge, my lord, before the Honorable Division Bench, my lord, in a writ petition, my lord. And, my lord, Lordship will find that order starts at page 313. The relevant paragraphs should be, my lord, paragraph 8, 9, and 10 at page 315. My lord, though the services of the petitioners were provincialized, paragraph 8, my lord, I'm reading, page 315. The services of the petitioners were provincialized under the 2018 Act. However, under section 6 of the Act 18, it was mandated that the non-teaching staff whose services have been provincialized under the Act shall get fixed pay specified in the schedule appended to the Act 2018 with effect on the date of the provincialization of services. Now, my lord, that was challenged, being agreed by with such fixed pay, the provisions of 41, 62, 636 for the schedule appended to the 18 Act are put to challenge in these writ petitions, being unconstitutional ultra vires, and it is projected the case with that the vested right of the petitioners to have the services provincialized and accorded under 2011 Act is ultra vires, and according to such vested and concluded rights cannot be taken away. Then, my lord, at the outset, Mr. Chaudhary and senior standing counsel, senior counsel for the petitioners submits that the similar provisions granting fixed scale of pay to the tutors under 2000 Act 2017 has been interfered by the coordinate bench in so-and-so versus so-and-so. And the present petitioners being similarly situated, the present writ petition can be disposed on similar lines. Then, my lord, para 13, my lord. In the given facts of the present case, page 316, my lord, we have the opinion that Mr. Chaudhary's senior counsel of the petitioners is correct, that the same principles of law is to be made applicable to the present batch of writ petitions, and directions may be issued in the light of determination made in Mohorali to extend scale of pay to the non-teaching staff whose services have been provincialized under the 2018 Act. It is an admitted position, though the services of the teaching and non-teaching staff of venture education institutions were sought to be provincialized under the scheme of Act 2011, stuck down. However, two different legislations were enacted in 2017 for provincialization of services of teaching staff of ventures education institutions of that, and the Act 2018 for provincialization of services of non-teaching staff of the venture education institutions. Under 2018-17 Act, the tutors were provided fixed scale of pay till acquisition of their qualifications to be recognized and upgraded as teachers. However, as recorded here and above, it was held by the coordinate bench that the services of tutors were provincialized, and the same were brought on the government fold. The regular scale of pay was to be given to them. Therefore, we are also of the opinion that similar principles of law shall be applicable in the case of non-teaching staff whose services, though had been provincialized, were brought under the government fold but were paid fixed scale of pay. So, my lord, accordingly, my lord, within a period of 4 weeks, my lord, the scale was sought to be asked to be determined, and my lord, they are entitled, my lord, scale of pay. Now, my lord, in a similar situated cases, petitioners approach this honorable court, my lord, page 313.
Who has approached this court?
Well, some other similarly situated persons also approached, my lord. Of course, these were, my lord, of with regard to, my lord, these were all college employees, my lord. And, my lord, there is another case where secondary employees, my lord, approached this honorable court. And this honorable court passed an order, my lord, asking them to file a representation and for consideration of the case, my lord. Page 330 it starts, my lord.
They have been asked to file representation
Representation, my lord, and their cases will be considered.
in terms of the division bench judgment.
Yes, my lord. So I'm praying for similar order, my team dispose of.
Why do you require similar order? What is stopping you from filing a representation, even without the order of the court?
No, that's true, my lord. But then when we approach them, my lord, they said, my lord, we will not be given the salary. And those who have approached, my lord, will be given the salaries. We learn that's made a statement, my lord. That's the reason, my lord, we have come to this honorable court, my lord. When we, my lord, approached, my lord, many inquiries, my lord, we are told, my lord, that we may not be given the salaries, my lord. That is the reason we approached, my lord. Para, my lord, 26, we made a statement, my lord.
So everything originates from this Mohar Ali Sheikh's case.
My lord?
Mohar Ali Sheikh's
Yes,
case.
yes, my lord.
It started from Mohar Ali
Mohar
Sheikh's
Ali
case.
case. Mohar Ali was with regard to, my lord, tutors, my lord.
Hmm.
But the same principle has been extended to, my lord, these people also where they challenge.
What is your basic claim?
Basic claim is, my lord, they are getting fixed pay, my lord. They should be given a scale of pay.
Okay.
That's the basic.
You are what?
We
You
are
ME school teachers.
grade 4 employees, my lord.
You are grade 4 employees.
Grade 4 employees. My lord, this-
In ME schools.
my lord,
In ME
schools, ME
schools.
schools, my lord. I know that there's
Somebody put the fan a bit low. Either I'm not audible to you or some problem is there.
something with them a lot.
Out there that, what do you call that? It's an inverter. Oh, those box out there. That also makes a lot of sound. Fan also makes a lot of sound.
Something is wrong with the lordship's microphone. It's not something echoing. It's not the voice is not.
Is it not coming properly?
I mean, coming, but it's not coming in the way it should have come. My lord. Something is wrong there.
This is the problem with technology.
True, man.
There were days when we never used this microphone, isn't it? So anyway,
So, my lord,
you are a grade 4 employee
great point.
under the ME schools.
Yes.
Different ME schools.
Different
Oh,
ME schools.
Different ME
Different ME
schools.
schools. We give them the list.
How many petitioners are there?
49. Yeah, my lord, 49, my lord.
49.
Yes.
And you are getting fixed pay.
Fixed payment.
You say that you should be given scale of pay.
Yes, man. We
In terms
challenge-
of this judgment passed by the division bench.
Yes, my lord. Mohar Ali was with regard to teachers, my lord. This honorable court in the division bench, my lord, extended this, my lord, to the my lord,
Tutors.
to the my lord, no, non-paying. Yes, that was for tutors. Mohar Ali was for tutors.
Mohar Ali is tutor.
Tutors.
Then division bench,
Division bench, my lord, again extended it to my lord, my lord, the non-teaching staff.
non-teaching staff.
Yes. That's the other judgment I was reading, my lord. Same
So,
principles. have been applied, my
Non-teaching
lord.
staff, are the grade 4 not included in the non-teaching staff?
Yes, my lord. Yes, my lord. Yes.
Then,
Included, but my lord,
but they say that unless you go to the court,
yes, my lord. My lord, when inquiries we learned that my lord, we cannot, my lord, they will not.
any statement to that effect?
26, my lord. 26.
Paragraph 26.
26. Learn to inquire the office of the DE Assam that the benefits of regular scale may not be extended to the petitioners.
You all are working under whose establishment?
All under the similar director of elementary education, ma'am.
And what is the school that you're working under?
My lord, the schools are ME schools. We've given a list, my lord, of the
It's a
schools,
provincialized school.
all provincialized. These have been now been provincialized, and under which, my lord, our services were provincialized. So we are getting, my lord, fixed pay in that.
Provincialized but getting fixed pay.
Fixed pay.
Yes, what do you say?
Today is the first day. Office
Today is the first day. Can it
the
not be
notice may-
disposed of?
notice may go, my lord.
No, can it not be disposed of?
Yes.
We will direct them to
Notice
file a representation
My lord.
in terms of that division bench
Separately, let them
judgment,
file separately.
and they will consider,
Yes.
and I think you should file a separate
Yes,
representation.
yes, yes. All the petitioners, my lord.
Yes, heard, Mr.
And-
Net counsel for the petitioners and Mr. P.K. Bora, Lanet Standing Counsel, Elementary Education Department.
For respondent number 1 and 3.
For respondent numbers 1 and 3, Miss R.M. Deka, R.M. Barua. For respondent number 2. So having regard to the nature of the grievance projected by the petitioner is taken up for disposal at the motion stage as agreed to by the parties. Court Master, Kim. You call some technician, some echo is going on. It is echoing,
Yes, echoing.
echoing. Next, para, the case of the petitioners is that they are working as grade 4 employees under different provincialized schools. And they come under the administrative control of the Director of Elementary Education, Assam. Bracket respondent number 3. So the grievance expressed is that although their services have been provincialized, they are only given fixed pay. Whereas they should be given scale pay in terms of the decision rendered by the division bench of this court in Mohar Ali, Sheikh and others versus State of Assam and others, 2024, 5 GLT 689, which was again relied upon by another division bench.
It's Abdul Muttalib, my lord, page 152.
At the beginning, but in WPC number 3239 public 2023, which was disposed of on 5/8/2025. Bracket Abdul Muttalib and 147 others versus State of Assam and others. Those bracket. Stop. The learned counsel submits that the petitioners in Mohar Ali Sheikh and others, Supra, were tutors, whereas in Abdul Muttalib and others, the petitioners were The petitioners have been informed that their case will not be considered. Next para. The learned counsel submits that similarly situated persons had also approached this court by filing WPC number 5232 of 2025. Bracket Krishna, Vaishya and others was state of Assam and others, close bracket, which was disposed of on 8/9/2025 by directing the petitioners to submit their respective representation before the director of elementary education. With a further direction that if the petitioner's case, if the case of the petitioners are covered by the earlier judgment of this court passed by the division bench, a similar benefit should be extended to them. The learned counsel submits that a similar order in the instant case may be passed. Next para, considering the above submissions, the petition is disposed of by direction to the petitioners to file their respective representations before the director of elementary education within a period of how much time? With-
1 month.
1 week.
Representation, my lord.
Yes, yes,
Within 10 days time.
within 10 days time,
10 days time.
with a claim for payment of scale of pay in terms of the earlier judgment rendered by the division bench. Stop the director upon receipt of such representation. Did I say individually? This will file it. Okay, that's good. The director on receipt of the representation shall consider the same. And if it is found that the petitioner are indeed covered by the said judgment, similar benefit should be extended to them.
Well, item number 20 and 21 are also similar, but in item number 20, they are college teachers, well, college may not non-teaching staff. And my lord, 21 will have secondary, they are secondary, higher secondary and secondary school. High schools and high schools, higher secondary schools and senior secondary schools.
No, just a minute. Item number
20, my lord. So
20.
they'll college, so they'll be under the director of higher education.
Then
My lord, and my lord, so far as 21 is concerned, my lord, they are, my lord, in my lord, high schools, higher secondary schools and senior secondary schools, they'll be under the secondary department. Director of secondary education. This is item 21 and 20.
high schools, high secondary schools and
My lord, higher and senior secondary schools.
Lordship,
20.
items regarding 20, Lordship.
23. 20 is higher.
This matter may be disposed of.
okay. Item 20 also will be similar order. Only thing is that petitioners are college teachers.
So, college, my lord, like junior assistant, senior assistants,
I'm sorry, they are
senior assistant,
senior assistant,
junior assistant,
junior assistant,
library assistant,
library assistant,
assistant librarians,
assistant librarians,
and grade 4 employees
and grade 4 employees
working in various colleges.
in various colleges.
Yes,
And respondent would be the director of
higher
the-
education.
higher education.
Higher.
And counsel would be Mr. D. Upamanya. Correct?
Yes, for 1 and 2. And for 3, Lordship.
D. Upamanya for 1 and 2,
1 and
1 and 3. RM Barua for 2. That's all?
That's all.
This is item 20. Then item 21,
21, my lord, they are, my lord, senior assistant,
senior
junior
assistant,
assistant,
junior assistant,
library assistant,
library assistant,
library bearer
library bearer,
in grade 4
grade 4
and grade 4 employees working in different high schools,
and grade 4, huh?
high schools.
Then high schools, high secondary schools, then senior secondary schools,
Senior secondary schools. They will be under secondary department,
and
director of secondary.
director of secondary education
Secondary.
department.
I
Then,
for the respondent number 1 and 3, madam.
Mr.
U Sharma,
U Sharma for respondent numbers
1 and 3.
1 and 3.
Yes.
Then RM Barua for 2. Finance, huh? That's all? So item 20, 21, and just now 70.
17, 20.
These are all common orders. You give me with the
Development.
file, okay? With the file you sent me, I'll check it also.
Development.
Yes. Acha, the sound. Okay. ठीक है. None appears for the petitioner. The matter is called. Just again after the Puja.
Herein, my lord, petitioner was placed under suspension following his arrest in a police case, my lord. And although, my lord, he was behind the bar for more than 48 hours, my lord, he was placed under suspension, my lord. Lordship, kindly come to page 17, my lord, suspension order.
No, what do you mean? Although he was and behind but more than 48 hours.
48. That's why, my lord, he was placed under suspension, and my lord.
No, that word although. Although should not be there. He was more than 48 hours behind bars, so a suspension.
Impugn order is there at page 17.
Page 17.
17. After no review, no charge sheet, nothing has been.
This is the suspension order.
Lordship.
When were you arrested?
He was arrested on 5/12/2024, my lord.
And suspension is from that date.
Yes,
Or what?
and order was issued on 4/1/25.
So this has not been reviewed
No, my
till now.
no.
Now,
No charge sheet,
are
no
you
anything.
behind bars?
No.
When bail was granted to you?
My lord, bail order is there. I am closing, my lord, on 18/12/24, lord. At page 18, just next page.
1812.
18/12,
Did you inform
lord.
to the authorities
Yes,
that I'm on bail now?
yes.
When did you inform?
It is the order of the learned session judge, my lord. 18/12/20. Inform করা হয়েছে। Thereafter, I made representations to the.
Information or.
Sir. 24. 24.
It is taking the order in the passport.
Lordship? Yes, yes, yes. Yes, ma'am. My lord, these are my representations. If lordship may kindly come to page 22. These are from my prayer from and lordship may kindly come to page 24. 24 also, my lord. It is their letter, my lord. Yes, it is just my prayer to raise my suspension allowance. It is his representation, my lord. Actually, word is not proper, but representation he has made, my lord. And if lordship may kindly come to page 24, my lord.
My lord, one hearing was done, my lord. Can you see page 25? He was called for. So can you come, can you be allowed? Maybe allowed taking. Yes. Yes.
Yes. Yes, children.
And elementary. All the. Yes.
Develop.
May I please, Your Lordship? Lordship, I beg your apology in respect of item number 22, Lordship. I was on lax in code number 7, Lordship. Item number 22, Lordship. Lordship. No, Lordship. I have a colleague, Lordship. He has. Lordship. Lordship, the petitioner has paid for payment of his releasing of his area salary with effect from 1/7/1996 to 28/2/2010. Area salary, Lordship. Lordship. Yes, Lordship. Petitioner was initially appointed as a graduate teacher science at Kanaimora High School, Lordship, at South Salmara. The Lordship will find the appointment letter at page 19, but his service was regularized with effect from 1/7/1996. That is his appointment letter. He was appointed temporarily and this was extended from time to time. Yes, Lordship. Lordship,
He said. Order was passed, Your Lordship, 2284/2008 itself, Your Lordship.
no, he could not file a contempt because of the issue of the limitation. So
Now 25.
now at page 31, your lordship will find after the order was passed in 2008, the headmaster of the concerned school, he had written a letter to the inspector of school, wherein the statement of the details of the area salary is
18
reflected.
years time gap, your lordship.
Then page 34,
No, wait.
and 35, your lordship may kindly see. On 25 to 2019, again the petitioner had written a letter to the inspector of school. For the last so many years, the respondents are not doing anything to release his area salary. Now on 29th of February 2024, he had retired superannuated from service
Oh, wait.
without the area salary. Lordship, these are the letters. He had been approaching the respondents, Lordship, since 2011 to 2019. And the respondents are sleeping over the issue.
There are other forum is still there, your lordship. 2023 SSC online, your lordship SSC 1307 Bisitronanda Behera versus State of Orissa, your lordship. Settled law is there, your lordship. Your lordship, there is a admitted position where he can approach the civil court also, your lordship, pertaining to this, your lordship. Another forum is still available.
If the respondents are disputing my status that I am not entitled to this particular area salary, then only the case of civil court will
Civil court.
arise. Here, the respondent number
Okay.
7,
Yeah.
who is the headmaster, who is an authority under the respondent department, he himself stated, Lordship. And in fact, the statement was countersigned by the treasury officer of South Salmara. There is no dispute with regard to the area salary which the petitioner is entitled to.
3 years time bound is there, your lordship. To approach before the outbreak. And here it is 18 years time gap is there, your lordship.
Lordship. আর পড়ালো।
Thousand eight. Eighteen years. In the meantime, your lordship, we would like to file our affidavit. Not extra copy. Okay. I'm appearing for 1 to 5.
See. No. May I brief for a date, Lordship? Lordship. The file person backs at some.
May it please the court. Chief, here the husband of the petitioner, my lord, he was initially appointed, my lord, as a stipendiary teacher, my lord. And my lord, he died, my lord, on 17/3/2023, died in harness, my lord. My lord, after his death, my lord, the authority, my lord, granted the other benefits like, my lord, DCRG and GIS and other benefits. But, my lord, they have not paid the compassionate family pension, my lord, in terms of, my lord, notification dated 14th of September 2017, which is at page 123, my lord, annexure 10. My lord, the relevant clause is at page 124, clause number 5.3, my lord. Where the employee dies before superannuation, the family pension equal to 100% of the last pay drawn by the deceased employee be paid for a period up to the date of deemed superannuation of the deceased employee, that is the date on which the employee would have superannuated had he been alive. This would compensate the loss of family income to a large extent and fulfill the retirement of compassionate conditions arising out of the death of the serving employee. Then, my lord, next, my lord, 5.6, my lord. On attaining the date of deemed superannuation, the CFP, contributory family pension, will be converted into normal family pension. This normal family pension shall be fixed at 50% of CFP from the date of deemed superannuation till 67 years of age of the deceased employee. So, my lord, under this notification, my lord, the petitioner is entitled to receive the 100% of the last pay drawn by the deceased employee till superannuation. And, my lord, his date of my lord, after that 7 years, 50% as a normal family pension. So, my lord, here the petitioner, my lord, lordship may kindly see the death certificate, my lord, at page 18. 18 annexure 2. Lordship, in the left-hand side, it is mentioned the date of death is 17/3/2023 and age of decease was 52 years, my lord. So, my lord, he would have retired, my lord, had he been alive, my lord, in the month of March 2031. Other benefits they have been, petitioner has got, my lord, DCRG, but not compassionate family pension at the rate of 100% of love. Right.
Oh, my God. Because this, we do not have a role as the particular for teacher, backup or center. I'm for 80. Let me party and you're standing. DPF paisa.
DPF,
The paisa.
my lord, here what happened, my lord? These stipendiary teachers, they were brought under the new pension scheme, as because they have been granted the regular scale of pay in the year 2006. Thereafter, my lord, a number of writ petitions were filed before this honorable court. And after hearing all the parties, this honorable court observed that the stipendiary teachers, they will covered under the old pension scheme of 1969, but not under new pension scheme. Here, my lord, in the meantime, my lord, the petitioner has been granted the account of NPS. So my prayer is that the amount credited in the account of NPS of the deceased employee, that has to be converted in the GPF, my lord. As because they are, Lordship may kindly produce page, my lord. 119, my lord. The judgment by which the stipended teachers, they were brought under the old pension scheme, my lord. Page 119.
Where's the beginning?
Beginning at page, my lord, the long judgment, my lord, page. Page 27, lecture 9. The relevant portion at page 119, my lord. Paragraph number 118, Roman 1. The writ petitioners who come within the fold of stipendary teachers are entitled to the benefits under the rule of 1969, and they are not covered under the NDCPS 2009. The said petitioners are also entitled to subscribe to the GPF. The said petitioners would also be entitled to all other pensionary benefits to which a government servant of corresponding rank is entitled to.
See, what about the petitioner's husband, isn't it?
My lord.
He was a stipended teacher.
Initially, he was appointed as a stipendary teacher.
Then?
Then, my lord, he was sent for training, my lord, in the year 2005. And after completion of the basic training, junior training, he was granted the benefit of regular pay scale. So, my lord, because they were given the scale in the year 2006, so under the office memorandum of the finance department, they were brought under the new pension scheme. And being thereafter, my lord, a number of writ petitions were filed, and this judgment was passed that they will be covered under the old pension scheme and not under new pension scheme, and they are also entitled to GPF also.
In this regard, I have to submit. But at the moment, such prayer is not there. Anyhow, prayer may not be there, but anyhow, fact is there. But if he's to get the GPF, then he's to be brought under GPF.
Yeah.
He's supposed to have one GPF number, account number, because as it is, my learned friend, what is submitting, it is fact. It's fact. Please case, my lord, as husband of the petitioner died, whether before that GPF account is opened or not, whether this after opening this NPS account is been converted to GPF or not, that has to be here. It's a department, because this is to be part to get, then only GPF will get.
My lord,
if he doesn't have account, how will be?
Yes, my lord, I have stated in paragraph number 7, my lord.
Even if it is open, my lord, I'm submitting a card. If it is open, my learned client having GPF account number, and if GPF account any amount is there, definitely will pay. He's pay. The GPF is his payment.
Yeah.
Not my our. But this to be a certain whether GPF account was opened or not.
No, it was not open, my lord. I have
Not
stated.
open means I will pay.
My lord, I have stated in paragraph number 7 at page 8.
No,
My lord.
where also.
You cannot have two numbers, isn't it? One is GPF account number and one is NPS number. You have to have either one of them.
No.
Can you have both?
No.
No, that is not, my lord.
So he does not have
No,
GPF.
no. We GPF account, because new pension policy reported GPF account, they cannot open. Now it is according to my PPF friend that it is to be NPS to be converted to
GPF.
Correct. So
for that. He has to open GPF account. And this NPS amount to be converted to GPF amount.
no,
Then
he-
only we can pay.
correct. He himself cannot open the GPF account. Na?
No,
It has to be processed.
That is a process, because this process for account
Now,
opening account GPF,
As on
he has to
today,
some signature is required. As he died, that is the problem that's coming out.
as
You know,
on-
I'll
But
put that aside, I'll take instruction.
the amount deducted from my salary in the NPS account, that is lying in the account and that has not been paid. So my prayer is that the amount credited in the account of NPS, that has to be converted in the GPF account.
We cannot do ourselves. This department has to do it, because NPS amount is not with us.
this is the first day. So
Actually,
we-
let us have
we
It may-
get a
it-
response.
We'll clarify, we'll submit my lord, his pay, GPF his amount. We are ready to pay.
But
My lord,
Mr.
I have an interim prayer.
Parameter of
What interim prayer?
Interim prayer of my lord, the current salary in the rate, at the rate of 100% of the last paid run, that has to be paid, my lord. As because he died in the year 2023, till today, my lord, they have not been paid anything, my lord, in the name of pension, my lord. So my interim prayer is that, my lord, the pension at the rate of 100% of the last paid drawn by the deceased employee, that has to be paid, the current salary, my lord. From the next month or
Interim will be considered on the returnable date. At Mr. A. Hassan, learned counsel for the petitioner, who submits that the husband of the petitioner was initially appointed as a stipendiary teacher and later on adjusted against a retired vacant post. And he completed the basic training, junior basic training successfully. So he was then allowed to draw the regular time scale of pay with effect from 31/8/2006. And was brought under the new defined contributory pension scheme. So similarly situated persons had approached this court by filing WPC number 6403 of 2021, amongst others. And the writ petitions were disposed of by common judgment in order dated 31/3/2023. With the finding that the petitioners who come within the fold of stipendiary teachers are entitled to the benefit of rules of 1969 is the pension rules.
Assam Services Pension Rule 1950.
Assam Services Pension Rules 1969. And they are not covered by the
New defined contributory pension.
new defined contributory pension scheme of 2009. To stop accordingly, they will be entitled to GPF. To stop, the learned counsel submits that the petition is also squarely covered by the case of the husband of the petitioner is squarely covered by the said decision. But he expired after retirement or before retirement.
My lord, he died in harness. Before.
But the husband of the petitioner died in harness on 17/3/2023. Stop referring to the notification dated 14/9/2017, bracket annexure 10. The learned counsel for the petitioner submits that the petitioner is entitled to family pension equal to 100% of the last paid drawn of the deceased employee as per clause 5.3 of the said notification. Stop. He further submits that clause 5.6 provides that upon attaining the date of deemed superannuation, by the late husband of the petitioner, comma, the CPF has to be converted into normal family pension, which shall be fixed at the rate of 50% of the CPS from the date of deemed superannuation till 67 years of age of the deceased employee. Stop. During this period of 7 years, comma, the normal family pension will be revised periodically as and when the normal pension is revised. Stop. However, the petitioner in the instant case has been deprived of the said benefit. And therefore she is before this court. The learned counsel further submits that pending disposal of the writ petition, the respondents should be directed to release the current contributory family pension at the rate of 100% of the last paid drawn by the husband of the petitioner. Next para, in view of above, issue notice of motion returnable by 4 weeks. Esquire, Miss Esquire for respondent numbers 1 and 3. RM Deka for respondent number 2 and 7. Mr. C. Barwa for respondent number 4. 1, 3, and 6, okay. Then 5. Okay, MD Burman, additional senior government advocate for respondent number 5. Petitioner to serve requisite copies of the writ petition to the learned counsels appearing for the respondent within 2 days. Also issue notice on the interim prayer, returnable by 4 weeks as well.
My lord, pendency shall not be a bar, only that much.
Pendency is not a bar for the respondents to mitigate the grievance of the petitioner. Like
Obligement.
that's item 24.
May I please your lordship?
Yes.
Lordship, the matter is regarding deduction of tax, lordship, from the arrear salary. Petitioner is agreed by it.
Tax, what tax?
From the arrear salary, lordship, income tax,
Income tax.
lordship. Lordship, firstly, lordship, there is
Is
an
it,
order
it's
of
not
this
permissible?
Lordship,
Is it not permissible to deduct tax?
lordship, her income is below the taxable limit.
I see.
And from the arrear salary that was granted to her, from there, the income tax has been deducted. And a huge amount has been deducted. Lordship, firstly, there is an order of this honorable court that lordship will pass at page 20. She is an assistant teacher, lordship, in elementary education. Now, page 24 is the operative part. The last paragraph I'll read, lordship, page 24.
This is by the petitioner only.
Lordship, the petitioner. She was aggrieved by the non-payment of salary, lordship. Then, lordship, this honorable court therefore directed the respondent number 2 to pay the salary and allowances of the petitioner on the basis of the time scale of pay admissible to her with effect from November 2003 within a period of 3 months. That was an order of 2014, lordship. Then, lordship, the amount was not paid. She preferred contempt, lordship. And thereafter, lordship, in the year 2019, the amount was released Page 25, Lordship 25B, there is an order regarding sanction of amount.
Hmm.
It's 25B, Lordship, that is the original copy.
Yes.
That was issued by the Deputy Secretary Government of Assam to the Accountant General. The subject is sanction of rupees 15,64,734 for payment of area salary in respect of Srimati Seoli Laskar, assistant teacher of so-and-so school under DEO Kasar Silchar during 2018-19. So, my lord, here was a sanction of rupees so-and-so for area salary for with effect from 5/8/2009 to 28/2/2017.
So
In the
from,
fourth line,
Mhm.
Lordship will find a period.
okay,
Then Lordship,
fourth line,
Lordship, that is the period.
where?
With effect from 5/8/2009 to 28/2/2017. This is the payment of arrear salary, Lordship, the amount of 15 lakhs.
Mm.
Then Lordship, the entire amount was not paid to her. She was only paid rupees 10,78,000, and out of it, 3 lakhs were deducted as income tax, Lordship. And
Pe-
the
Period is 5/8/2009,
9 to
to
28/2/2017.
70.
Lordship, that is the period.
So deduction is 3,52,853.
Lordship, page 27, I have preferred a representation that is to the District Commissioner. Prayer for release of remaining arrears of salary and crediting of 91,000 to my GPF account.
91?
1,000 to my GPF. That is another amount deducted as a GPF amount. From that amount only, from 15 lakhs, 91,000 was deducted as GPF account, and another, Lordship, 3 lakhs.
You have retired.
52,000.
You have retired.
No, Lordship, I'm working now. That is from the arrear period, Lordship, the arrear salary.
So if it's deducted GPF amount, then you will be getting that, isn't it?
Lordship, but the income tax that was already deducted.
No, income tax, though, deduction is another thing, but the GPF amount,
That
of
she might be getting, Lordship, but
91,000, she'll be
Lordship,
getting
she'll be getting,
as
Lordship.
and when she retires or.
May I read the representation, Lordship? It will become more clear. With due respect and humble submission, I beg to state that I'm serving as an assistant teacher presently posted at Radha Madhav Junior Basic School, Kasar Silchar. She is presently working there, Lord. Earlier, I served at 373 number Boraibasti LP School under Narsinghpur Elementary Education Block, Kasar. During my initial service as a secondary teacher at 688 number Bitila LP School, my services were not permanent and I received a salary of so-and-so. Subsequently, my scale of pay was regularized and I was sent for training during which my regular salary was stopped. As per the direction of Elementary Education Assam letter dated so-and-so 8/5/2017, my monthly salary was fixed at 1,800 from 2003. Consequently, the department sanctioned my area salary amounting to 15,64,734. However, the then BU of Narsinghpur Block Sri Ajay Chauhan and his subordinate head assistant so-and-so credited only 10,78,819 towards my area salary and 91,000 was GPF investment and under some other scheme. When I inquired about the remaining amount, the BO informed me that 3,52,853 was deducted as tax payable. However, I am not an income tax SSC as my annual income falls below the taxable limit as per government norms. Further, the amount of rupees 91,000 has not been credited to my GPF account till date. So, my lord, this was
91 is not credited
Lordship. Till now, it is not credited,
to a GPF account.
Lordship.
How is that?
Lordship, the deduction part, Lordship will find at page 31, there is another letter from the BEO regarding her application. A letter was issued by the BEO. The deduction was made clear. There is a table at page 31, Lordship. Lordship. That is a letter from Block Elementary Education Officer, Narsinghpur, Kasar, to Deputy Inspector of School, Silchar, Kasar. Report regarding application submitted by Srimati Seoli Laskar, the then assistant teacher of so-and-so school under this education block, praying for her arrear salary, etc. Then Lordship will find a table there, the amount of allotment received, that is 15,64,734, already drawn. That is the drawn amount she was given her account, that is 10 lakhs. and the GPF amount 91,000, the deduction part, GPF amount 91,000, and the income tax 3,52,853. Now the net amount she was sanctioned 10,78,890. That is the amount, Lordship. So my Lordship main grievance is that the income tax that is 3,52,000 is far below far more, Lordship, because she is not an income tax assessee as per her income, and also Lordship,
How much was your monthly income?
Lordship, around 33,000. So it will be below 5 lakhs. If I'm not wrong, Lordship. Then if the income is below 5 lakhs net income, then
So
income
if you
tax-
receive it monthly, then amount is not taxable.
Lordship.
Now here's a case wherein it has accumulated to 15 lakhs.
Lordship, it is
Probably
okay.
that's why they taxed you.
But
That's
this
why
is
they taxed you.
area, but it is the arrear salary. It is the arrear amount, arrear salary, they cannot deduct tax, if I'm not wrong, Lordship. And also the calculation part, the charter accountant, the petitioner approach a charter accountant, he have specified, that is at page 34, Lordship.
Mm.
That is tax on the total income, if it is calculated, page 34, Lordship.
Yes.
If the Lordship comes to the first table, the last part, the total 15,64,734. That is the salary received in relation to previous year, and the tax on total income that comes at 6,527 if it is calculated.
This is for which period?
That is, Lordship, it is given as to the arrear part, Lordship. If the arrear part, the tax is calculated, that will come as 6,527.
On one hand, you're saying that it's not taxable.
But
On
even
the-
if the
On your,
tax is
and on the
imposed,
other hand, you're saying that even if tax is to be given,
that will be less, Lord.
6,527.
Lordship. And the amount they have deducted is 3 lakhs. That is far more, Lord. That is my case.
Yes, anyone?
Oh, the company, I have more on the paper. The amount that he was required to pay was less. He could have paid for refund of the tax authorities, my lord. Giving that calculation in the return. So far as income tax system, if he was not liable to pay that amount, and the amount was credited into the income tax authorities account, he could have filed a return and claimed the refund. That's the normal process, as I understand.
No, that is one part, but that is one part. What she's saying is that income being not taxable, no amount is to be deducted. But then again, even if it is to be taxed, only this much. That's what she's saying.
And in that case, file the return before the authorities in a proper manner, claiming refund. That's the process. Now, because the amount has already been credited into the account of the authority, probably the education department has no role to play at this moment.
Who are the respondents? Who have met you? Who have you met?
Respondent number 6, Office of the Accountant General.
Lordship, the elementary department, I have made a party, and the block also I have made a party, block elementary education. Also the accountant general and the assistant commissioner of income tax, Lordship, I have made a party here.
Assistant Commissioner.
Lordship, I had serial number 7, Lordship.
Okay, we have any standing counsel? Income tax?
Yes, Mr. Kyle is there. and
SC Kyle.
Mr. S. Chetia is there. I'll inform them. Lordship,
Lordship, may issue notice.
Okay, I heard Miss
8 Talukdar, Lordship.
Talukdar, learned counsel for the petitioner, who submits that the petitioner has retired as,
She's working,
She's
Lordship.
working,
At present, she's
she's working.
working, Lordship. Assistant
Okay.
teacher.
Submits that the petitioner had earlier approached this court by filing WPC number 3859 of 2010, claiming scale of pay as assistant teacher. Of what? Assistant teacher of what?
Assistant teacher, Lordship.
LP or
Of LP school, Lordship.
of LP school.
Lordship.
So the writ petition was disposed of as allowed. Right order dated 23/2014. with a direction to the respondents to grant her the time scale of pay with effect from November 2003 within a time frame. Stop. After persuading the authorities by filing a contempt petition, the amount of rupees 15,64,734 was sanctioned for payment of her area salary for the period with effect from 5/8/2009 to 28/2/2017. However, to the surprise of the petitioner, an amount of rupees 3,52,853 has been deducted towards income tax, and rupees 91,000 has been kept aside.
GPF,
For GPF. Stop. According to the petitioner, her income slab does not come under the taxable limits, and therefore no deduction could have been made towards income tax. Stop. Secondly, rupees 91,000 has also not been deposited towards her GPF. Stop. Agree if the petition is before this court. Next para, the learned counsel also submits that the petitioner has approached the chartered accountant who made the calculation to the effect that the taxable income would come to rupees 6,527 only. Stop. She therefore submits that even if the area salary, even if income tax is to be deducted from her area salary, it cannot be anything more than 6,527. Next para, in view of above issue notice of motion returnable by 4 weeks.
I am for the respond number 6.
Mr.
B sharp.
B. Sharma appears for respondent number 6 and accept notice. And you, Ms. K. Das, for respondent numbers 1, 2, 3, 4, and 5. Petitioner to serve notice to respondent number 7 through Mr. S.C. Cal. S.C. Cal, Standing Counsel Income Tax. And thereafter submit the acknowledgement receipt to the registry as proof of service. This is the matter again after
Extra copy, please.
4 weeks. Petitioner to serve requisite copies of the writ petition to learned counsels are paying for the respondents today within 2 days.
Much obliged, sir.
May it please your lord. My lord, this is a writ petitioner is a physically disabled person, my lord. And he challenged the advertisement which is at page 71 Annex 10.
What is this thing?
My lord, here, my lord, the APSC advertised the post of Inspector of School, District Elementary Education Officer, and Deputy Director under Assam Education Service
Hmm.
for 7 posts, my lord. Out of 7, no post has been reserved for PWBD. My lord, since, kindly consider, my lord, since 2017, I have annexed those advertisements. Since 2017 till 2025, they advertise a total 34 number of posts without keeping any vacancy, any reservation for physical disabled person, man.
How much is the reservation to be kept?
4%, man.
4%
4%, man.
of the post advertised.
4% of the total cadre strength. Now, my lord, when the petitioner challenged this impugn order by filing the item number 14, they have come with impugn order dated 19 August, my lord, which is at page 89. Here, my lord, they have given one reservation for the deaf and hard of hearing. One post they kept reserved for physically disabled person without considering the section 34 and rule 11. Rule 11. Kindly come to rule 11 of the rights of persons with disability rules 2017. My lord, here, my lord, kindly peruse rule 11, which is as per section 34 of the act, my lord. Before going to 34, my lord, I am placing this, my lord. Rule 11, sub-rule 2, my lord. Every government establishment shall maintain a vacancy-based roster for the purpose of calculation of vacancies for persons with benchmark disability in the cadre strength as per the instruction issued by the appropriate government from time to time. Now, kindly come to the state government WEM, which is at page 47, annexure 5 of my read petition.
Yes.
My lord, may I read, my lord?
Yes.
Quantum of reservation 2.1, my lord. In case of direct recruitment, 4% of total number of posts to be filled up by direct recruitment in the cadre strength in each group of posts, grade 1, grade 2, grade 3, and grade 4. My lord, next, my lord, kindly come to page 48.
No, just a minute. You're reading 2.1.
2.1. Here, my lord, OM read as subject reservation of posts for persons with benchmark disabilities and other concession.
So, persons with disabilities will differ.
Yes, ma'am.
There are different categories, isn't it?
Yes, ma'am.
So how to resolve that?
My lord, I am placing that, man.
Okay.
According to clause 7, effective preservation and maintenance of roster at page 48. Every government establishment shall maintain a separate post-based reservation roster, registered as per format in annexure for determining affecting reservation for the persons with benchmark disability. One is for direct recruitment and promotion. 7.2. Each register shall have cycles of 100 points. It's a 100 points roster that to be maintained. And 100 points, and each cycle of 100 points shall be divided into 4 blocks comprising the following points. First block, point number 1 to point 25. That means second block, point 26 to 50. Here, my lord, the case of the respondent is this, my lord. Total cadre strength is 41. In that event, number 1 post will be kept for PWBD and the number 26. So for the post cadastant of 41, they have to give 2 posts. Am I clear, my
No.
my lord?
Let us go again.
My lord, I am placing again, my lord. 7.1. Every government establishment shall maintain a separate post-based reservation roster register as per format annexure for determining. And 7.2. Each register shall have cycles of 100 points, and each cycle of 100 points shall be divided into 4 blocks comprising the following points. First block 0.1 to 0.25, second block 0.26 to 50, third block 0.51 to 75, fourth block 76 to 100. That means for completing 100-point roster in any cadastre, they will appoint 4 person. Because
4%.
4%. So they will.
So out of 100, 4 will be
4
appointed.
will be appointed. How it will be can.
But if the post is the
41.
total post is 41.
41. So they have to follow the register in number 1 post, 1 PWBD, in number 26,
26 another one.
another one.
Now question is who will be considered, because they belong to, if you come to 2.2, page 47. 2.2, there are different categories. Category A, B, C, D, E.
Yes, madam. Yes,
So
madam.
how will that be?
How I'll place that, madam. Kindly come to clause 2.2. Number 1 A is blindness and low vision. They are not giving any that category. They are giving B, deaf and hard hearing. So 1 post is kept reserved for deaf and hard hearing.
Yes.
Now come to C, locomotory disability, including cerebral seizure, leprosy cured, dwarfism and attack victims, and muscular dystrophy. The petitioner comes to this C category.
C category.
C category.
So,
So if they follow the roster, they have no alternative but to consider the case of the petition.
How?
It is not that he has to be appointed. Only they have to give the reservation for them.
that I understand. You see, thing is that as per the addendum, they have given the post, 1 post for deaf and hard hearing.
Mine.
Why do you say that this has to be given from category C? It could be from any category.
No, madam. No, madam. Kindly, that is here, my lord. That query will be cleared from 8.1. I'm placing 7.4 first. Kindly come to 7.4.
Yes.
1 point of each block shall be treated as reserved for the respective category of persons with benchmark disabilities and fill up as such. So 1 block, 1 to 25, 1 block, 7.2.
Will be
Next, second block.
No, 1.25 will be for blindness and low vision.
Blindness possibly this category post is not suitable. That's why they went to deaf and hard hearing.
Deaf and hard hearing.
Yes, my lord. Now next block, then next block will come to locomotory disability. One thing more, my lord. There is another point, my lord. That is clause 8. Clause 8 of this WEM is saying that inter-se exchange and carry forward of reservation in case of direct recruitment, public promotion. My lord, a right has been created by this WEM for carry forward and for backlog. Admittedly, this post was created way back in early 90s. The post of inspector of school. We don't know, my lord. We could place only the advertisement from 2017. This is the education department. They can say, my lord, whether they are maintaining the register from 1995, since the earlier act, the persons with disabilities, equal opportunity, protection of rights, full participation act 1995, which was amended by 2016 act, madam. My lord, a specific provision has been made for backlog vacancy. If they have not filled up any vacancies, and kindly come to clause 7.6.
But should we go for such kind of roving inquiry? What
My
was done, what was not done?
My lord, let them file their affidavit. Let them file their response.
See, your specific case is that there is no reservation given for PWBD.
My lord,
Now, ultimately, they have made an addendum.
my lord,
In the addendum, now they have added deaf and hard hearing,
my lord. This
which again does not suit your purpose because you belong to category C.
my lord, I am not interested for my personal benefit also. Kindly consider a department. It's such an important department. They are not following this, my lord.
No, that's not that.
Ma- ma-
I understand, you see, but the thing is that this is a writ petition,
Yes.
not a PIL,
No, I'm
wherein you are saying that.
am for my right.
Mm.
And kindly see one thing, my lord, 7.6. After all the 100 points of rosters are covered,
Fresh cycle.
a fresh cycle of 100 points shall start.
So let them file affidavit.
Yes,
What-
my lord. Let them
what's
file
the-
affidavit, my lord.
See-
And they will bring the, my lord will specifically state that they will bring the roster on
See,
their affidavit.
See, but this part I have not understood. 2.2. There are 1, 2, 3, 4, 5 categories.
Yes, my lord.
Who will come at what time and who will come, will not come. This has not been clear.
My lord,
So-
from section 34, it will be clear.
It could be anybody.
Kindly page section 34 of the act. Act, my lord. I have furnished, my lord.
34.
Section 30.
Yes.
Every appropriate government shall appoint in every government establishment not less than 4% of total number of vacancies in the cadre strength in each group of posts meant to be filled with persons with benchmark disabilities, of which 1% each shall be reserved for persons with benchmark disabilities. Under 1% each for persons with benchmark disabilities under clause A, clause B, and clause C, and 1% for persons with benchmark disability under clause D and E. For D and E, 1%, and A, B, C, 1% each. That means 4% will be calculated like this.
No, A and B will be.
Again, I'm placing 1% each shall be reserved for persons with benchmark disabilities under clause A, B, and C,
A, B, and C.
and 1% for persons with benchmark disabilities under clause D and E. From D and E, 1% will be selected.
So total how
1%,
many? Total
and
2%.
A and B and C, 1% each. 1%, that is total 4%. So
Total is 4.
4.
But now it's only 2. 1% from ABC and another 1% from D and E. That means 2%. Where is the remaining 2%?
My lord, my lord, kindly consider 2% of total 41 cadre strength. And how it will be calculated? For A, they are not giving. For B, deaf and hard hearing, they kept one reservation. Next, kindly come to clause C. Next reservation is C. Then next reservation will come to D and E. Like that, there will be the roster will be maintained like that way.
So how do you say that as per the current roster, you,
Let them
that-
say, I am
that
not
C-
entitled.
C
Let them-
category, C
let-
category should become?
Yes, my lord. Let them say I am not entitled. Let them produce the register. Let them say, show us that, yes, they are maintaining the register all these years. This act came into force in 1995, the earlier act, and this one is at 2016. Now we are in 2025. This 95 act has came into force and holding the field for last 30 years.
Oh, the language is like that. It says, one person each.
Yes, my lord.
That you have to stress.
My lord.
If the word each is not there, then it doesn't make sense.
Yes, my lord.
Now-
One person each.
Each.
From A, B, and C.
A1, B1, C1 like that.
Like.
And for D and E, it's common. It's one
One.
person. So total 4%. Okay.
Total four. That's it.
So they'll make a roster. Then accordingly, if there's nobody available that year, it'll be carried forward.
Yes.
And after being carried forward, if somebody is still not available, then they will move on to the next category. So this is what it provides. Then there was an issue regarding you filing two writ petitions.
My lord, because the tendency of the earlier writ petition, this impugned order was passed. I have to challenge that.
Addendum came later on.
Yes, ma'am.
So that's why.
That's why.
Which one is the earlier writ petition?
The item 14, ma'am.
The PT 2313.
Item 14.
So anything to submit?
But in earlier restriction, we have filed affidavit in opposition.
Uh-huh.
The understanding of my understanding plan.
Hmm.
I would like to just clarify, add one thing.
Yes, add, yes.
Lordship may kindly come to section 33 regarding the identification. Lordship, PWPT reservation is a special reservation under Article 14 of the Constitution of Indian Law. And while implementing this lordship,
No, what you're saying? Section 33.
section 33 lordship,
Yes.
lordship,
Identification of post.
post, lordship 4% of the total cadre stand. Before implementing that 4%, first of all, the duty of the employer is to identify the post.
Hmm.
Which benchmark disability would be suitable for the concerned post. Suppose that I am a driver. The post is a driver. For the driver, that the expert committee, the employer, will identify to which benchmark disability would be suitable for post of driver. For hearing impaired, locomotor disability will not be suited for that post. That's why section 33 I am reading.
Read.
Identification the post for reservation. The appropriate government shall identify posts in the establishment which can be held by a respective category of persons with benchmark disability in respect of vacancies reserved in accordance with the provision of section 33. 2. Constitute an expert committee with representation of persons with benchmark disability for identification of such posts. Undertake periodical review of identified posts at an interval not exceeding 3 years. Now section 34. Every appropriate government after identification, next exercise. Every appropriate government shall appoint in every government establishment not less than 4% of total number of vacancies in the cadre stand in each group of posts meant to be filled with person with benchmark disability, of which 1% each shall be reserved for person with benchmark disability under clause A, B, C, and 1% for person with benchmark disability under clause D and E. Lordship, may I pause for one moment?
Yes, yes.
Suppose there are 100 posts in a cadre. In 100 posts, there will be a 4%, and this 4 posts will be filled up by the PWD. Then, who are those posts? Either category A, B, C, or D or E. For that, one exercise of section 33 has to be carried out by the government.
You have done that? Or was it done?
They have done it. I am coming closer. The earlier petition, they have filed with a grievance that from 2017, FTSC has conducted so many recruitment process of this particular post but not a single candidate from the benchmark eligibility have been filled up. So I have filed a affidavit in opposition stating that it is the before that. Page
Mr.
50,
Datta,
page 50.
today, do we require to go now to all that?
But
We're not disposing it out.
no.
We'll issue notice.
Yes, issue notice. But the petition has been structured
Hmm.
challenging the only the addendum without challenging the government decision to identify those posts. Finally, page 51 minute, page 50. Certificate by requisitioning authority. Lordship got it 10. In order to ensure proper implementation of provision of reservation of person with benchmark disability, the requisitioning authority, while sending the requisition to the requiting agency or authority, as the case may be, for filling up the post, shall furnish the following certificate of requiting agency. It is certified that the requirement of so and so has been filled up and vacancy reported so and so. Meaning thereby, Lordship, that requisitioning authority has to requisition us with a certificate that this post which are to be filled up from this benchmark disability, as in consonance with section 34, Lordship. Now, Lordship, Lordship,
We are not on
let-
that dispute, my
I
lord.
not disturb you.
We are
Thank
not
you.
on that dispute, my lord.
Plus, I am expressing the law only, Lordship, not, and neither opposing him nor making my stand, just to make the correct stand before the court. Now, page 89, Lordship. Yes, Lordship, just I am pointing out. One point, Lordship, I am not opposing Lordship, his pair also. Lordship, without challenging page 88, this is the decision of the expert committee. Lordship, kindly come to page 88. It is the aftermath of the earlier litigation. To the Secretary of Government of Assam form, to the Secretary of PSC. Sir, with reference to the subject headed above, I am directed to inform you that regarding inserting the provision of 4% reservation of PWD candidate with respect to the advertisement to the post of Inspector of School and so and so under Department of School Education, the Department of School Education has decided to prefer the PWD candidate, namely deaf and hard of hearing, as approved by the Department of Social Justice and Empowerment among the categories mentioned in the OM, that is so and so, subject to adherence to time and conditions. So they have identified, Lordship, this post. So if an Lordship 4 number of posts is allotted, so he will not be benefited, Lordship. All the 4 number of posts will be filled up from that category only. This is my point, Lordship.
No,
This is my, and his submission,
no.
it does not hold any water, Lordship. It is totally incorrect and erroneous submission he has been made.
4% means, my lord, 1% each for, that is the law, section 34. 1%
confusing.
from each disability.
Without section 33 understanding, how can he stress upon section 34?
Which states that the petitioner had earlier instituted WPC number 2313 of 2025. Stop. It may be seen that WPC number 2313 of 2025 in WPC number so and so, okay. The petitioner has challenged only the notification dated 13/2/2025. And by the instant writ petition, the petitioner has challenged the addendum dated 19/8/2025, bracket Annex 18, which has been issued subsequent to the filing of the earlier writ petition. Stop. Therefore, there seems to be no irregularity in the petitioner filing 2 writ petitions. Next para. Heard Mr. G. Boysia, learned counsel for the petitioner, who submits that The petitioner is aggrieved with the steps taken by the respondent authorities in filling up the post of Inspector of Schools / District Elementary Education Officer / Deputy Director under the Assam Education Service without giving any reservation for persons with disability as mandated under the Rights of Persons with Disabilities Act 2016. So the learned counsel submits that under section 34 of the Act, 4% of the total number of vacancies are required to be reserved for persons with benchmark disabilities. Stop. He also submits that there are 5 categories of disabilities mentioned under the said provision. And that one person each has to be reserved for category A, B, and C, while one person for category D and E. Stopped by the impugned addendum dated 19/8/2025. The respondent authorities have reserved one post for category B. Without any justification for giving a preference for category B. Stop. He submits that the petitioner otherwise belongs to category C. And therefore has been deprived of being. Next para, Mr. P.P. Datta, learned standing counsel, APSC, submits that Section 34 is preceded by Section 33, which provides for identification of post for reservation. Stop. The identification has to be done by the appropriate authority in the state government, which has apparently been done as communicated to the APSC on 15/7/2025, bracket NHS 17. Stop. As such, the petitioner cannot have any grievance as projected in the writ petition. Next para, considering the above stand, it appears that proper consideration of the issue has to be requires to be done, and for which a notice, and for which reason let a notice of motion be issued, returnable by 4 weeks. Ms. P. Das, learned standing counsel, Secondary Education Department, accepts notice on behalf of respondent number 1, 2, and 3. Mr. P.P. Datta, standing counsel, APSC, for respondent number 4 and 5. And name? PCA. Miss PCA, for respondent number 6. How do you spell your name? Okay, see. Okay, just write it down for respondent number 6. Petitioner to furnish requisite copies of the petition to the counsel for the respondents appearing today within the 2 days.
The pertaining petition, one,
Yes.
earlier one,
Itu head kori pun dia. Itu order tu head kori pun.
we need to find out.
You file.
And in that case, notice has not yet been issued.
Hmm?
In earlier case, notice
Earlier-
yet to be issued.
Not yet.
Not yet, not. We have furnished instruction and court, as per court direction, we have filed affidavit.
Okay.
That notice be issued also yet.
List
Yes,
again after 4 weeks. Then in the other case, separate order, okay? Heard Mr. G. Vaishal and counsel for the petitioner. Issue notice of motion returnable by 4 weeks. Then who else? I think the rate of respondents are same. No, not same.
Not same, my lord. It's
Uh,
stated.
Ms. P. Das Learned, standing counsel secondary
One,
for respondent numbers
one with
1, 2, and 3. Mr. P. P. Datta for respondent number 4 and 4 and 5. That's all.
My lord, item 13,
Uh.
notice may be issued for interim order.
13. Again, you go back to 13, the earlier one. Also issue notice on the interim prayer, returnable by 4 weeks. Yes.
Obligement,
This is your book.
my lord.
This takes care of item 13 and 14.
My lord. Next date is,
I said 4 weeks.
the date may be fixed, my lord.
I gave a date, returnable by 3/11.
Obligement.
Possibility down left 10 minutes to make a repair. 10.
Okay, call next slide.
Okay.
What is timing, Lord? At
Last occasion. We are supposed to get the instruction because of yesterday, the holiday losses could be fine. I couldn't send the instruction, so it is under preparation losses. Let it take about Friday losses. After, otherwise we have already sanctioned that amount. It is, we have, after vacation
On
losses.
reopening.
as we agreed, after.
The created by the practice list the matter of the reopening
It is posted
after the Puja vacation.
applied.
The SMT GST shall obtain up-to-date
Up-to-date.
instructions
Applied.
by the next date.
Applied. Here also losses after vacation.
In terms of the last court's order, the registry has identified the affidavit filed on 11/9/2025. And the same has been placed on. And the same, no. Affidavit dated 11/9/2025, okay? Filed by the sole respondent. However, the petitioner is, as the petition is absent, learned counsel for the petition is absent, let the matter be decided again after the NPT. The SMT history learned counsel appears for the respondent.
Hartnell, may can fix on Friday. We have already issued a compliance order. We'll focus it on Friday losses.
That's straight for, no, right like this. Mr. SNP Christie learned counsel for the respondent submits that the compliance order has already been issued and prays that the matter be listed on Friday.
Yep.
Good.
Obliged.
That's straight for this one.
It is a lot, my lord. My humble prayer is to issue order for personal appearance of the contempt, because I have some time constraint, my lord. I am retiring on January 28th. And they are delaying the matter purposefully.
So I am preparing respondent number 2 here. But I am praying for 4 weeks time, my lord.
4 weeks time.
My lord, at least personal appearance is required, my lord, because already
No,
much
my lord.
time has elapsed, lordship.
No, that
I'll read out the order, lordship. Lordship may kindly come to page
is the
12.
first time we are appearing.
Page 12. It begins at page 11, bottom, lordship. In view of the submissions of learned advocates of both the parties, and as agreed upon, this court is inclined to dispose of this petition by directing the respondents' authorities, especially respondent number 4 and 5, to consider the case of the petitioner for his promotion to assistant professor stage 3 in accordance with rule prevalent at the relevant time within a period of 3 months. That was passed on 29th of November 24, Lord.
When did you serve a copy?
Okay. It was
You have served a copy on
what
3rd
the
of December.
respondent.
3rd of December, you served copy. Who's the respondent? Who's the what?
The president governing body of the college and the principal. They are obviously to start. Specific direction was issued to respondent number 4 and 5 in the writ petition.
We'll give them some time because they are appearing for the first time.
My lord. A very short time, maybe a lot, my lord, because my time constraint is there.
Quite 4 weeks time. Your good name? Mr. P. Kakoti, learned counsel, appears for respondent number 1 and 2. And praise for only 2. What about 1? One has received for both the respondents. Mr. P. Kakoti, learned counsel, submits that he has instructions to appear on behalf of respondent number 2 and prays for 4 weeks time to file the show cause reply. No one appears for respondent number 1. Top office note dated 28/2025 shows that respondent number 1 has received the notice on behalf of himself as well as for respondent number 2. Oh, for 2, you're for 2?
Yes.
Okay. Then office note dated, you cancel that. When was the steps taken? No, then you're right. What did I say? Please read. Beginning. Stop. Next para. Office note dated 28/2025 indicates that as per the report of the process server, notice has been received by respondent number 1 for himself as well as for respondent number 2. So under the circumstance, notice is deemed to be complete on both the respondents. Please the matter. But what? What? What much is fulfilled from today?
Immediately after reopening, effective.
Oh, let's have it put that. The matter of 29, 2025.
Right.
If the respondent number 1 is not present, consider passing appropriate order. Respondent number 2 shall ensure filing of the show cause reply by the next day. The one who pays for the applicant when the matter is for list again after they have seen the date. Puja Vati. $44. Appropriate benefit. After puja application. Then one more sentence and before the appropriate date.
Please.
Yes.
Ship, justice service is complete. The rest number 5. The matter was taken up on 18th of this month.
Who is for respondent number 5?
And for 1 and 2 losses, 1 and 5 is as the stepping loss.
Where is he?
Up here, he will do the 1 and 5. There's some would put at the office control. There's some maybe Ballavine that
Vakalatnama is defective.
some in
No, he has not filed Vakalatnama. That's what is indicated here.
file with but then means after 18 lot Indian days we file not file. As that's only so
On what pages is he appearing?
that's good lot.
There is no Vakalatnama.
In the meantime, we'll file it, not file lot. I am for 1 and 2 lot. Okay, for okay. From him, in between he filed out local law. Therefore, on 18th of
So,
From 18 Lordship, as state law, no, the matter was taken up on 18 Lordship.
Then
I'll discuss in 1 and 2.
1 and 2 will represent.
Yes.
And your friend will represent.
He is from Guwahati Nagar.
Respondent number.
That's number 34. Yes.
So 1, 2, 3, 4, you are there. 5 is missing.
No, that's the thing that at the paying document. He filed.
He's appearing. Where is he? I have not seen him.
Present not here.
He's not here.
At present.
So he's not appearing.
Hello.
How do you say he's appearing? He's not appearing. And he said he filed Vakalatnama. His Vakalatnama is not found anywhere.
I talked to him. Some problem.
Have you filed your affidavit?
What main party is the Guwahati.
Okay.
Formal part.
What university has filed?
Counter to file.
You filed. Okay. What is your response?
Lordship, I will not.
Senior is coming. Will you sit some other day?
No, if it's possible, can the matter be taken up at the end of the vote, Your Lordship, today itself?
Any urgency?
I think
Why? You have taken admission already in LLM course.
LLM, yes, Your
You have been selected as a law clerk also.
And also, Your Lordship, I have cleared 6 semester also, like aggregated, I have 70%. Only because of this paper, I am starting it.
You cannot start your LLM course.
Cannot
You
start it.
cannot start.
Because of the registration process, Your Lordship, I need to produce the provisional certificate. If Mr. The learned Standing Council GU is appearing today, then I request this Honorable Court to kindly take this matter at the end of the podium.
There he.
Lord, we have already filed affidavit in Ogoy, but
I'll not be filing any.
He will not be filing reply. So can it be taken up for disposal?
taken up immediately after taking.
He says there's some urgencies there.
Your Lordship, the remedy I'm sitting here, Your Lordship, is a direction for a fresh evaluation here because of wrong and negligent evaluation. And Your Lordship, a similarly ditto similar case, Your Lordship, was taken in Madras High Court. And I would like to produce it because Your Honorable Lordship, how they have dealt with it, if Your Lordship permits it. Same case here.
You could give a copy to Mr. Pupan also. But this is not a disposal order.
It's not a disposal order, Your Lordship. It's
Then-
an interim order.
How does it help you?
Here also, the public prosecutor was directed to reevaluate it. Your Lordship.
Lord, it would be better if taken up for final hearing. I have on 23rd of October.
All right, 23rd.
All right.
Okay. Office note dated 22/9/2025 indicates that respondent number 5 submits that Mr. S. Das has not filed Vakalatamba for appearance on behalf of respondent number 5. Petitioner in person is present and Mr. S. BJ
For
appears for respondent numbers 3 and 4. And Mr. S. Buya appears for respondent number 1 and 2. As agreed to by the parties, list the matter for admission hearing on 23rd of October.
Much obliged, Lord.
Ma'am. Applicant have filed an additional affidavit by compliance with the previous order of justice tax taken.
So we'll list it after the vacation. Your good name?
Mean to say,
Mr. M. Chaitya, learned counsel for the petitioner, submit that he has filed an affidavit as regards service of notice upon respondent number 6 and 7 by way of Dusty. He submits that although respondent number 6 has received the notice, but respondent number 7 has refused to accept the notice. Under this circumstance, notice is accepted to be complete upon both the respondents. List the matter after the ensuing vacation, puja vacation. In the admission column.
if you
Morning, somebody mentioned. You had mentioned.
He wants some time, immediately after vacation, a date may be fixed. Long
Okay.
pending case.
Mr. S.A. Hassan, learned counsel for the respondent number 7 and 8. He said to have some personal difficulty to appear before the court today. On a prayer made on his behalf and not objected by the site, this the matter. On principle. Give a date.
13.
30.
Is your lordship. But the affidavit is yet to be filed, your lordship. The last two occasions they have sought time.
Yes, secondary, who's there?
We are yet to file the affidavit. Look, can you give us after application of it? We file the affidavit in the meantime.
No, what has happened with this case, kind of cases? Some special bench has been constituted.
Also, previously
This-
it was constituted,
Then what happened?
but this particular petitioners are not into that category. You know. They have challenged the rule, your lordship. Here we have sought the right, as a right we have come. That rule 25 was there, which was under challenge, your lordship. But
Okay, Mr. Chishti, how much time?
lordship,
As paid for by Mr. S.M.P. Chishti, Planet Standing Council, Secondary Education. Further 3 weeks' time is granted to obtain instructions and.
lordship, as a last chance, your lordship, because the last two order reflected. Only peruse the last order. Because the instruction first they have sought they have told it is went for vetting, your lordship. The last occasion there was some miscommunication.
And the same shall be as a last chance. This again, after 3 weeks.
Taken. Stabilize your lot.
Met plate action. Take, file, take it.
You have not filed. Yeah, who's appearing?
Last occasion had time though.
Elementary. Which is SQL, learned council, elementary, for elementary education department, place for, and is granted further 3 weeks time. To pay instructions and file counter affidavit. Let's again after 3 weeks. Interim order passed earlier to continue
Immediate after petition, but
till the next.
I'll fix a date, but
Give a date. List again on top. List on pattern.
May I please, madam?
Yeah.
My lord, in this matter, my lord, I've gone through the instruction. They've received the instruction. In the instruction, they are not objecting to our prayer. Otherwise, I'm claiming for the old pension scheme. Ma'am. Otherwise, I was put under the new pension scheme. But the only dispute which remains is like with regard to the date of, from the date when I'm going to receive it. I'm praying for the matter to be fixed on Friday, matter 26th. I need some instruction to be taken from my client so that the matter can be disposed of on 26th.
Yes, who's for the
No, my lord, since 26th, just it can be disposed of, my lord. The matter only one thing, my lord, with regard to that date of issue when they are saying since 2005, I'm saying 2004. Only with
but
that.
where's the instruction?
Well-
You have given him the instruction, but not to the court. Which okay.
I got it from her.
They say it's with effect from 31/8,
2005.
2005.
I'm claiming it to be of 2004. Since the exam where I have to pass, after passing out of that particular exam, only then I will be entitled to get old pension scheme. So that was passed by me on the year 2004. So that is the only question that I just want to take an instruction from my client. If he is satisfied with 2005, then my lord, we have got no. Otherwise, they are not objecting to our prayer.
What is your claim with effect from?
2004, my lord. It is. My
Where
lord,
is
may kindly come to page number 7, paragraph number 3. That the petitioner stated as per the stipulated condition as mentioned in the appointment order 31/3/1995, the petitioner was allowed to undergo 1 year in service primary teachers training course at basic training center Hailakandi by issuing the admit card on 19/12/2010, wherein the roll number of the petitioner was mentioned as 60. The petitioner has successfully completed the training and accordingly notice dated 28/5/2004, my lord, was issued by the Principal Basic Training Center, Hailakandi, wherein it was mentioned that the rule number 6, which was allotted to the petitioner, has cleared the repeater of first and second quarter periodical evaluation with regard to the basic subjects. So my claim is in this manner, basically. Since 28/5/2004, I have cleared that particular exam. So, page number 7, Lordship.
See, their instructions also based on something.
Well-
It's based on the letter received from the office of the SCRT. So they say, as per the report received, you have cleared.
Lord, if it is
The JBT course. What is JBT? Junior Basic Training. You have cleared it on 31/8/2005.
yes, 28/5/2004. That is my claim. No.
Sound, how's the sound
Yes,
sounding to you? It's echoing, isn't it?
Echoing.
It's echoing.
Yes.
Somebody might like to sing also if this kind of effect is there.
Technically, we say it is
Delay.
delay effect.
Delay effect. So that is the thing. Your JBT course you have passed on 31/8/2005.
That is.
So that is why they say that you are entitled from this date. And on what basis, according to
Yes, perfect.
before passing?
Manoj, may kindly come to page number 27.
Yes, 27.
That is the annexure number 4, my lord. So this is the RTI that I have actually filed, and the reply I have got it in the RTI. So the relevant portion is in page number 28, my lord. That is the type portion. My roll number was 60, lord.
Roll number?
My roll number was 60. 60.
60.
Yeah.
Yes, then?
Like following candidates are hereby declared to have qualified the final quarter periodical evaluation primary teachers training certificate 2004. It is to be noted that they are neither required to submit assigned number appears retest or in this particular paragraph number A, my lord. Here my name is not there in paragraph number B. That is following candidates shall reappear in the subject mentioned so and so periodical evaluation, the date will be notified. So this was my roll number. At language learning, serial number 1, roll number is 60, ma'am. Now, if I come to C, it is mentioned here that the report of 1 and 2 quarter periodical evaluation cleared their back subjects. I have failed, but I have cleared my back subject, and the roll number is 60. Page number 29, it is specifically mentioned that 60, roll number 60 cleared his back subjects of both first and second quarters. Now, that was in the year 2004. Since he have cleared his examination in the year 2004.
No. What does it mean, this notice? We'll understand.
No, this was a notice. If we come to, this is the type version, Pratik. If I come to page number 30, this
30,
is this is the office from the office of the Principal Basic Training Center.
not legible.
Yes. Now, what I'm trying to make out a point is, Lordship, since I have passed my examination on 28 as per the notice on
See,
28 May
See,
2004.
just a minute.
Yes.
This notice, the paragraph A part,
Yes.
it says that these following candidates have cleared.
Yes.
B says following candidates have not cleared,
Yes.
and they are periodical evaluation. So date will be notified in due course. You say your roll number is 60.
60.
It is there.
Yeah.
Then now come to paragraph C.
Yeah.
Again, it says that the report of the first and second quarter clear their back subjects. When did you clear the back subject?
Yes. I've cleared my back subject.
When? This notice is, what is this? Is all in one case. A says this much has cleared, B says this much not cleared, C says they have cleared.
Yeah.
What kind of document is this? Is it not contradictory?
May kindly come to
page number 11, page number 36. This was the claim that I have made before the authority. Now, that why they are saying that I have passed 2005 and why I am saying 2004 is that, my lord, when I have given my repeat examination, the repeat was cleared by me. That was not known to me at that point of time. In the year 2005, again, a fresh examination was given by me. When a fresh examination was given by me, in the year 2005, I have cleared that exam.
You have cleared twice.
I have cleared twice. That is the issue now. I have cleared twice.
How is that possible?
Yes, that is the main issue. That is why they are saying that I'm eligible from 2005. When I made the RTI, through the RTI only I came to know that no, I have cleared my repeat exam in the year 2004 itself. That is my entire issue.
What appears to be, my lord, from perusal of the rectification and I have heard this submission. But the board of contention lies with my lord whether when my lord the SCCRT had recognized my lord passing of that specific. For that reason, my lord, we need to visit the authorities of SCA because if it is after 1/2005, or it is well aware, 1 February 2005, the cutoff date. It is on the other side, my lord. It is post 1/2005. It will come within the admit of new pension scheme. And if it is prior to 1/2005, my lord, it will come within the admit of old pension. This is precisely what is the leading thought for here. He says, my lord, that he is entitled to the benefits under the 1969 pension rule, meaning thereby, my lord, the old pension scheme. So therefore, my lord, SCCRT is not a party respondent before the honorable court. So let him dispute, my lord, let them controvert, my lord. Otherwise, my lord, so far, finance department instructions are there on record, my lord. We have paid, my lord, received that, my lord.
What is the cutoff date?
Cutoff date is, my lord, 1st of February 2005. 1/2005. That is the date of when, my lord, the new pension scheme was promulgated and it came into force. And lordship is aware, my lord, of that Punima Hurry adjustment, my lord, that is now holding the field. Where, my lord, the honorable court, my lord, had examined the cases of various categories of people. Pertaining to, my lord, whether one may be in the category of access teacher, my lord, one may be in the category of drop teacher, what may be in the category of, my lord, teacher under the OBC scheme, so on and so forth. So one category that has been called out by the honorable court in Putima decision is the category of stipendary teachers. And the stipendary teachers have been given the benefit, my lord, of my lord, the old pension scheme. Albeit, my lord, albeit they will have to satisfy and establish, my lord, that they had they had, my lord, passed out all the requisite training courses, my lord, prior to 1/2005. Now, here is the case before, my lord, where lordship has seen, my lord, that a SCERT is now saying, my lord, that it is post 1/2005. But in that view of the matter, my lord, it would be, my lord, prudent on the part of the petitioner if he fits, my lord, the authorities in SCERT.
My lord, I'm just praying that let it be fixed on Friday. If my client is satisfied with that, then we can go by the instruction. Or else otherwise he's suffering for that reason. Otherwise, they are not declaring that I'm not entitled to, but only the dispute is with regard to me. So if that may be satisfied on Friday.
Okay, please write Mr. Sukhya, learned counsel, preparing for the elementary education, has produced the instructions in the form of communication dated 25/3/2025. So, Mr.
K. Vishwakarma.
K. Vishwakarma, learned counsel for the petitioner, submits that he may be given some time to obtain instructions from his client, of as paid for list on Friday.
20. I'm obliged, ma'am.
Mr. Arbor Pujari, learned counsel, appears for the finance department.
And so, like,
Yeah, please. Along.
lordship, in this case, the petitioner has approached this honorable court because
marks was not uploaded in the system by the college authority, and which has been subsequently admitted by the college authority and had written to the respondent. The respondent number 3 had written to the examiner, etc., for making appropriate corrections. Now, the stand of I'll take your lordship first of all to Annexure G, page 34. Now, this is the letter.
Why is it
issued by the
listed today otherwise? Is it listed?
Annexure G, page 34. Your lordship, it is a letter dated, letter issued by the principal, Acharpa, to the controller of examination. With respect, I would like to bring to your kind attention that the project assessment mark of one of the students who appeared in HS final have been recorded as absent. However, the students had duly appeared for the project assessment and had submitted their respective project within the stipulated time. All relevant supporting documents are enclosed herewith for your reference. And he had enclosed, along with this covering letter, 3 documents, which are enclosed here as 30 and page 35, 36, and 37. 36 is the one which shows that she had obtained 18 marks.
Just a minute, just a minute. I'll just read out. So you were marked absent.
I was marked absent.
Principal says that no, there's some mistake.
There is some
Was
mistake.
present. That's
And
it.
Annexure T was the one he had admitted to that and written to the controller of examination for making the necessary correction.
Then
Now the respondents number 2 and 4, I find 2 affidavits.
who are they? 2 and 4?
Respondent number 2 and 4 are the education board and the controller of examination. And the respondent number 3 is represented here by Mr. Datta. Now, their stand is, as your lordship, in both the 2 affidavits, their common stand is that there is the SOP in existence, and the SOP does not allow modification after the thing has been uploaded in the system. That is their only stand, and they say that it was the duty of the college authorities to ensure that it was properly verified, and it should have been up. Now, my contention before your lordship is, I am not at fault. If there was any internal thing, my career is at stake. If the SOP is to facilitate the student's career education, now an SOP is not also specifically binding, and it cannot be used against a student
who is not at fault. She participated, she obtained the necessary mark. And because, and this is admitted by the College of Britain, that due to an inevitable mistake on their part, not in direct words, but that it was a mistake and it was not uploaded. And they
See,
have clarified by this letter.
By
And,
this page 34,
yes,
what is the reason assigned?
there is no reason as such
Then
out there.
There
But
has to be a reason.
there is no reason assigned, but they say that all relevant kindly look, they have not stated anything as to why it was not uploaded. But it is there, and your lordship will kindly appreciate that. I think in the last occasion, Mr. Senior Counsel, Mr. S. Datta had made a stand that this was an individual, today he is not there. But he had made us taken a stand that this was an inevitable mistake.
Okay, last time Mr. Datta was asked to obtain instruction. What is the instruction?
There was the internal.
No action taken. And for that mistake, somebody is suffering.
Otherwise, we have admitted to that mistake. We have better controller of it.
Now, how can that mistake happen? Somebody appears and you mark them absent. How is it possible? And when did you discover that?
I think it was on 15th of on the date after the exam.
Yes, on 5/5/2020.
Exam happened on which date?
The results were declared on 34/2020.
34.
34.
And how did you discover this?
I think the petitioner had was discovered.
Huh?
After they immediately intimated us, accordingly, we have controller by the data dated 5/5.
The petitioner herself has also approached the controller of exams by 2 letters. One is an annexure F and the other is annexure H, your lordship. Page 33 is the letter, first letter, immediately upon the publication of the award, this marks the result when it was declared.
What is this exam?
This was
Final exam.
final exam in HS, your lord.
In the subject of history.
History.
There was some external.
Yes.
In external, you were marked absent.
Yes. Your lordship may come to page 32, annexure E. This is the mark sheet that is uploaded in the system. At the bottom is the history mark is given. Theory, she had secured 43 marks, but in the practical, it is shown as ABS absent, and as a result of which, the grand total though is 338. She has been marked as compartmental in history. That is, she has failed in that exam.
Then,
and because
no, then after that 34 came. Some mistake, you were present.
Yes.
Now question is how many marks did you secure?
18 marks, your lordship. Page 35 is the.
Who has evaluated this?
This is the certified by the principal.
And given to whom?
Awarded to Alina. The name is there.
No. And this rectification or this marks has been sent to who? Which authority?
The higher secondary marks, page 35, your lordship. Page 35.
I'm on page 35. To whom has it been sent, this marks?
Yes, the name of the student is marked in page 35.
Name is there, marks is there, I know.
Yes.
Question
roll number
is
also there.
Question is, after discovering that he or she was present.
Yeah. And the roll number, your lordship may come to page 36. This is the attendance sheet where she was present on that day. Just the third column shows the attendance sheet.
Oh.
This is also.
No, that is okay. That much is okay. I'm saying that after you discovered that she was present,
Yes.
she, isn't it? He or she?
She.
She. So this was sent to the board or not?
Yes, this was the controller of exams. It was sent, your lordship. Page 34. This is the forwarding letter, which was, I was drawing your lordship that it. Controller of exam.
Petitioner has sought for rechecking. Is it?
We have sought for that the mark should be brought into record and our marks should be reflected. The proper mark should be reflected.
No, at page 33.
This was the rechecking because at that point of time, I didn't know rechecking means I sought for that I was present while it was being marked as absent. If your lordship, I noticed my marks in the history project was not added to it, which I got a compartmental. I have submitted my project and given bye-bye as well, but has been marked as absent. So she wanted a clarification from the department as to why she has been marked absent when she was present. Thereafter, the college authorities also wrote to the board that she was in fact present, saying that this is there. And the marks have been also reflected. And the last representation made by her is that
Who is representing the board? Board.
the board, they have taken us, they have filed two affidavits. One has been filed today, but the common stand is clause 10 after lordship, they have annexed, if your lordship takes up their affidavit at, which starts from page 40. And they are putting emphasis on two provisions. At page 44, a guideline is there. They have annexed the guideline. Here, they are putting emphasis upon clause number 10 and 11, which your lordship will find at page 45. And their main emphasis is that after the head of the department, which in this instant case is the respondent number 3, have uploaded the mark, that would be treated as final and there is no provision for correction. But my submission before lordship is, these are internal things to streamline the functioning. But if there is a fault in the system, if there is an error not occur or which is not due to the candidate, how should the candidate be made a victim to this?
Where is that once entered will not be corrected?
This is 11, your lordship. Last two lines they have put emphasis upon. Once submitted, there is no scope of editing present or absent status of the candidate. They say that this is the stand and this is the stand they are taking, that they cannot correct it. But my humble submission, your lordship, is I, not being I was not aware of it. I participated. It is the fault of the thing. And your lordship, in an earlier occasion, your lordship, in a similar matter, had interpreted this, though it was stated that it should not be treated as a precedent. I have given the copy of this order passed by your lordship. Here, your lordship had interpreted this particular guideline. This was with regard to Gurucharan College in Kasar. I'll take your lordship directly to para 9 of your lordship's order. If I may read out your lordship. From a perusal of the records available, it is seen that it is apparent that it was due to certain administrative shortcomings on the part of the college authority that the internal marks obtained by the petitioner in their business studies had not been furnished, thereby resulting in marking of the petitioner as absent for the said assessment. The college authorities have also admitted their shortcoming as written to the respondent, requesting necessary correction. On the other hand, learned counsel of the respondent number 2 has referred to the guideline of practical and such and such. It is true, such guidelines are necessary for effective management of the various roles to be played by those involved in the examination process. However, when certain omissions have been made for bona fide reasons, same cannot be overlooked when non-rectification would mean the student concerned would end up losing one academic. This was the thing, observation made by your lordship. in a similar situation.
It says that it will not be treated as precedent,
Yes, that is
but,
there.
but
that
you are
is-
relying upon it as a precedent.
I cannot rely upon it. I have stated that, Your Lordship, it is specifically stated by Your Lordship that it should not be relied, but the facts are almost, except for the college and the students, the thing is same, Your Lordship. And
So
another
we'll
thing
dispose it off, we'll dispose it off then. Where is the facts?
with regard to the earlier case,
Your case, today's case.
this case, Your Lord.
Okay, synopsis is there.
Yes, synopsis is
We'll
there.
dispose it off.
No, I will take Your Lordship directly to the paras where I have mentioned the fact.
That's okay, I got it. All right, Mr. A. Biswas, learned counsel for the petitioner. Mr. S. Datta for respondent number,
3, Your Lord.
and Mr. S. Bhuya for respondent 1 and 5, and Miss P. Devi,
2 and 4.
counsel on behalf of Mr. T.C. Kutia for respondent number 2 and 4. Of having regard to the nature of the case projected by the petitioner, the petition is taken up for disposal. Next paragraph is the case of the petitioner that she had appeared in the higher secondary what?
Higher
HS.
secondary, it would be final examination. Higher secondary final examination in the arts stream.
Higher secondary final examination in the art stream
Arts.
for the year 2025, conducted by the Assam State School Education Board. ASSEB bracket. Something wrong with your synopsis also. You say commerce stream.
An error is there because it should be history. Arts.
Problem. It is the case of the petitioner that although she participated in the examination, she appeared for the examination as per the schedule. Where is your mark sheet? And had submitted her project, but when the mark sheet was issued, she has been marked absent. Insofar as submission of project report is concerned. Of the petitioner agreed with the same, submitted her representation before the controller of examination ASSEB on 30/4/2025. No? 25. And the Kachar College, the principal of Kachar College, Silchar, has also written a letter to the controller of examination, ASSEB, to the effect that the petitioner was inadvertently marked as absent for the project report. And that he did submit her project report in time as per the stipulation. and had scored 18 marks. Stop despite the same since rectification in the mark sheet having not been done, petition is before this court. Next parameter is this one, when counsel submits that according to the respondent, ASSEB, they are guided by the standard operating procedure bracket SOP issued by notification dated 16/12/2024. Wherein it is provided that there will be no separate online portal to mark the attendance in practical public project examination. To stop. The head of the institution and the internal examiner will mark the candidates as absent. For absentee students, and once submitted, there will be no scope for editing the status of the candidates. To stop, the learned counsel submits that there was no fault on the part of the petitioner, and that for the fault on the part of the internal examiner or the authority in the institution, the petitioner cannot be made to suffer. Next, madam, from a perusal of the materials available on record, it can be seen that the principal of Kachar College, Silchar, and the internal examiner have duly subscribed their signature on the marks given for project submission in the subject of history to the petitioner as 18 marks. And from the communication dated 5/5/2025, written by the principal of the same college, the petitioner was inadvertently marked as absent despite being present for the project, for submission of the project report. And therefore, it only appears that a bona fide mistake has occurred in the entering of the marks of the petitioner towards project report in her mark sheet. Of the SOP relied upon by the respondent ASSEP is basically to guide the authorities concerned for conduct of the project examination. And the petitioner cannot be petitioner not being involved in such an exercise conducted by the authorities concerned in entering the marks cannot be held responsible, cannot be deprived of the marks secured by her against the project report. To stop, therefore, this court is of the view that the petitioner should be given the marks as secured by her in the project report by making necessary correction in a mark sheet.
There was a seat kept vacant by an order of this. So after it is uploaded, I may be allowed to take admission.
So that admission in the Kachar College would be what?
One seat, if your lordship,
Does it become automatic?
that should be automatic, but a seat as per the order of this court on
So
20th,
there will be a criteria for admission, isn't it?
as per the, because it should be automatic in the sense because we will be getting the qualified mark that 18 mark is added and she will be marked as in the, from the compartmental till whatever division she secures after the addition of the mark.
No, for seeking admission in the college, there must be some criteria. What is that?
The criteria is there.
So your admission will be subject to that criteria
Yes.
fulfillment.
That observation.
Okay, this court, quite order dated
Order dated 21/8.
21/8/2025. had passed an interim order dated, as it had passed an interim order, just to the effect that one seat
Taking
art
note of
stream.
the submission, it is one seat in the art stream shall be kept vacant.
in
until
Qatar
further-
College, Silchar shall be kept vacant until further ordered. Now, since the instant writ petition has been allowed, as reflected here and above, the petitioner be considered against the said seat, vacant seat, subject to her fulfilling the eligibility criteria. With the above, everything is correct. Highly obliged. Yes, go. Bhuya, what is this matter?
My lord, this is a matter, my lord, as regards the recent recruitment process, StatCom recruitment, my lord, the government has initiated a process. My lord, and wherein an advertisement has been issued, and my lord may be pleased to find the initial advertisement is at page 45, my lord.
Yes.
My lord, by way of this advertisement, my lord, what they have done, they have not segregated or earmarked the different category of post, my lord, altogether. They have notified that 7,249 numbers of vacant post of graduate teacher art, graduate teacher science, graduate teacher Hindi, and graduate teacher Sanskrit of the different provincialized secondary schools under the Directorate of Secondary Education, Assam. Now, my lord may kindly note that in this advertisement, my lord, 4 categories had been earmarked, my lord. That is, and we are concerned, my lord, we are interested in the graduate teacher science, my lord, science category. Now, my lord, and when this advertisement was issued, then, my lord, the authorities had issued another order, my lord, addendum. My lord may be pleased to find that addendum. Page number 56, my lord.
46.
56, annexure 2, my lord. 56. Now, my lord, in this addendum, now they have, my lord, categorized and earmarked the different category and the name of posts, my lord. Herein, my lordship may be pleased to find that the graduate teacher science 2,111 numbers and graduate teacher mathematics is 1,736 numbers of posts, my lord. Now, my lord may kindly peruse that the graduate teacher, this column number 1, my lord, is the specifically targeted for the, my lord, mathematics. Graduate teacher mathematics shall have a graduation degree in the science with honors or major in mathematics and having physics, chemistry, or biology as the pass course or minor subject in the graduate level course, or the post-graduation degree in mathematics from a recognized university with honors or major in mathematics having physics, chemistry, or biology as a pass course or minor subject with at least 50% marks in either graduation or the post-graduation, and must have the Bachelor of Education B.Ed degree from the institution recognized by the National Council for the Teacher Education. So, my lord, this has been earmarked, and this criteria relates to for the purpose of those candidates, my lord, who are interested to apply for the posts, my lord, the name of post in mathematics. Now, my lord, I am troubling my lordship with the graduate teacher science category, my lord, which has been earmarked in page number 45, my lord. For the, my lord, in column number 2, my lord, this is we are concerned with. For the post of the graduate teacher science, the candidate must be science graduate or the postgraduate in science, having from recognized university with at least 50% mark. Page number 45.
Yes, I'm there.
From the recognized university with at least 50% marks in either graduation or the post-graduation or its equivalent, and the Bachelor of Education from the National Council for the Teacher Education of the recognized institute. Now, my lord, what they have done, by in the initial recruitment, TETCOM recruitment advertisement, my lord, there was no category had been earmarked for the purpose of mathematics and science, my lord. And this is only for the category of those graduate teacher science has been earmarked. Now, my lord, when I have just brought into my lordship's kind notice, my lord, at page 56 is the second category, that is mathematics, my lord. Now, my lord, what has happened in our case, the candidate who have this qualification of at page 56 is now started applying in our category also, my lord. That is the general teacher in the science stream, my lord. As a result, this category of persons, my lord, has the double benefit. Applying in the same recruitment process, they have a dual advantage, my lord. And they have already applied. And as a result, what has happened, my lord, they have overlapped us. Now, my lord, what has happened? My lord, may kindly turn to page number 99, my lord. Is just for an example, my lord, page 99, we have shown, my lord, that how this teachers has applied, my lord. Now, my lord, in page 99, this is a graduate teacher category, and they have applied for the post-applied graduate teacher science and graduate teacher mathematics, my lord. As a result, my lord, what has happened when this candidate who has the mathematics, my lord, has come in the cadre of graduate teacher science, they have overlapped us, my lord, and we have, my lord, has been now this graduate teacher science has been overburdened, my lord, overlapped by this graduate teacher science candidate, and as a result, the cutoff marks, my lord, we have been ousted on merit, my lord. My lord, may kindly see the cutoff mark category, which the 3 cutoff mark list has already been published, and we have annexed, my lord, all those. My lord, kindly turn to page 119, my lord.
Mr. Bhuya, have you challenged the addendum?
My lord?
Have you challenged the addendum?
No, my lord, addendum is not required to be challenged because, my lord, this is only for the purpose of, my lord, mathematics, my lord. Now let them apply in the mathematics. We do not have any objection. Now, my lord, this mathematics, those who has the honors in mathematics, my lord, they can go for the mathematics, my lord. That is the issue, my lord. Now the honors candidate in mathematics is again come in our category, my lord. That is, my lord, in that is the category of the general teacher science, my lord. That's where the all difficulty and the discrepancies arises, my lord.
But is it not permissible?
My lord, the in a same
page 45.
My lord. Yes, my lord,
Addendum is basically for the maths.
Maths.
45 is for the science.
For science graduate teacher.
It says this is the thing. It doesn't say that you have to be science major or science honors.
No, my lord.
So a person having science.
My lord.
Science, of course, with maths, they can come. Where is the bar?
No, my lord, the bar is not there, my lord. If some person has opted for the science, then he cannot go for the mathematics. Because my lord,
Which provision says that?
no, provision says, my lord, in a single. But, my lord, in the portal which the education department has, my lord, initially opened, in that portal, my lord, there is a provision that those persons, my lord, can go for only for the one course, my lord. Now,
how do you demonstrate the portal that you have to choose only one stream?
my lord, that portal we cannot, my lord, bring on record, my lord, because of this. It is a digital mode, my lord.
But where is the statement?
Statement we have given.
Portal has provision only for one choice. You cannot give double choice. But you have shown me this page number, what, 99?
199, yes, my lord. The 99
Not 199, page number 99 only.
99 is the, my lord.
What is this? Graduate teacher, post-applied,
No, my lord.
science and maths.
This is the evidence which we want to bring before my lordship is regarding that a candidate who has applied double.
Correct.
Apply.
So what is this document?
This document is
Admit card.
This is a document of the, my lord.
Admit card.
Marksheets come admit card. Marksheets come admit card for the document verification of TETCOM recruitment examination.
Mark sheet come.
Marksheets come admit card, my lord. for the document verification of TET-CUM recruitment examination 2024.
That is the second stage.
Portal of the-
Is it the second stage?
My lord has asked regarding this, my lord, portal statement, my lord. My lord, I am troubling my lordship with page number 21, my lord. My lord, page number 21, the paragraph starting, my lord, thereafter. Thereafter, at the time of making the online application at the concerned portal, the science graduate candidates could only apply for the graduate teacher science post and not for the graduate teacher mathematics post. However, surprisingly, later on from the mark sheets come admit card for the document verification of the TET-CUM recruitment examination of 2024 of some of the mathematics graduate candidates, it could be seen that the mathematics graduate candidate could also apply for the graduate teacher science post apart from the graduate teacher mathematics post. The petitioner begged to submit that this has been an act on the part of the state authorities which implies providing undue advantage to one batch of applicants mathematics candidate while at the same time depriving another batch of applicants, that is science graduates, from the level playing field, and which has been in violation of Article 14 and 16 of the Constitution of India, my lord. This is our basic case, my lord. Because, my lord, in a single recruitment process, if a class of person has been given the double advantage or the double benefit, and we have not been provided, my lord, that is in violation of 14 and 16.
When did you submit your form?
Lord, we submitted our form, my lord, on time, my lord. My lord, our applications from
Give
we
me
have
the
annexed,
date.
my lord.
Give me the date. What on
Yes,
time?
yes, my lord, we have annexed. Next quote. My lord, in due time, after the advertisement, it starts at annexure 3 from page 63, my lord.
See, first annexure, page 45. What is the date?
My lord, the first annexure, this is the advertisement on 26/12/2023, my lord.
From where you are saying that?
My lord can, yes, yes, my lord can find it on page number 50, my lord. Bottom of this page, my lord.
Okay. And last date for submission?
My lord, the last date for submission has been earmarked, my lord. Addendum. My lord, 27/12/2020. It is on 21st of the online application will be accepted from 20. My lord, may kindly turn to page 56, my lord. The online application, how to apply, my lord, in this category, my lord, may be pleased to find. The online application will be accepted from 21st of October 2024 to 15th of November 2024 midnight. And we did apply within this zone, my lord. And our application receipt, my lord, starts at page 99. No, it is not, my lord. Our application starts at page. Look, my lord, may kindly turn to page 63. My lord. Date number. My lord, this is the date, my lord, may be pleased to find. Oh. This is, my lord, on time, and my lord, when we downloaded it, that date is there, my lord, 23/6/2025.
See, thing is that I understand your grievance.
My lord.
If I've got you correctly. You're saying that the maths teacher can apply for science and maths. You can only apply for science.
No, my lord,
Thereby, there are so many people from the maths stream who are taking away your chances.
Exactly, my lord. By coming in our frame, my lord, their merit is higher than us. As a result, my lord, we have been ousted in the cutoff mark. But in the maths, my lord, the cutoff mark is very low. If we compare with the, my lord, this general science, the cutoff mark of the mathematics is very minimum, my lord.
But such is the prescription, you see, advertisement says that for science, you have to be a science graduate. For maths, you have to have the honors or major in maths. And also having physics, chemistry, and biology.
No, my lord, if we go by the, my lord, with all my very limited understanding, my lord, if we take the science stream, BSc, my lord, if a person is physics, chemistry and biology, my lord, he is also a science. Now, my lord, here it says that physics, chemistry, biology can go for the science graduate category. But, my lord, he cannot go for the, my lord, science, mathematics portion. But in the mathematics, those person who has the honors in mathematics can have the combination of the physics, chemistry, or that milot other stream milot, then he can go for the science as well as in the milot maths. Now, in a single recruitment process milot, a double advantage has been provided to the same class of person only because they have the honors in mathematics. That is the milot. That is the milot. I think my limited understanding milot is that it will barred by Article 14 and 16 of the Constitution of India, my lord. It is a discrimination.
Discriminate.
My lord. That has been, my lord, in a very limited span of time, my lord. I have found out 3-4 judgments, my lord, but I have not bring those today, my lord. Doctrine against the multiplicity of claims is also barred, my lord. That this, the Honorable Apex Court, my lord, has held that the recruitment rules should be, my lord, post-specific and category-specific and must be strictly enforced. Permitting a candidate to claim eligibility in more than one post in the same recruitment exercise would result in unfair advantage, my lord, discrimination and arbitrariness, my lord, and which court has held to be impermissible under Article 14 and 16 of the Constitution of India.
So what are you seeking today?
My lord, we
This
are
is for
seeking
motion,
today,
isn't
my
it?
lord, that those mathematics candidate who has come in our category, my lord, they should not be given the advantage in the, my lord, graduate teacher science. If some persons are there with the mathematics honors or trying to occupying or overlapping us, my lord, those candidates should not be given the undue advantage of having the science my lord, background or the science graduate background in our frame, my lord, because we could apply only in our category, my lord.
Okay, you are concerned basically only with the science stream.
Only science stream.
Now, what is the scheme of this recruitment process? What is happening now?
My lord, the third list has already been published, my lord. It
Third
is
list.
the third merit list, my lord. My lord,
Third merit list for
my lord,
science.
Science. No, for all category, my lord.
For all categories.
All, my lord, may kindly turn to page 121, my lord. It will clarify this stage, my lord. The cutoff marks for the final list, page 121. My lord, this is the, my lord, cutoff marks for the final list of eligible candidates for the document verification against the graduate teacher post of TETCOM recruitment 2024, my lord. Here is a, my lord, the graduate teacher arts. We are not concerned with this, my lord. The graduate teacher science and graduate teacher mathematics, that is serial number 3 and 4. Page number 121, my lord. The final merit page, my lord.
Science.
My lord, we are concerned with 1, 2, 3 and 4, my lord. My lord, may be pleased to find graduate teacher science. The stream wise has been given the cutoff mark, Assamese, Bengali, Boro, English, Hindi, Assamese, Manipuri, my lord. The last cutoff for the Assamese category, my lord, graduate teacher science has been shown as 72.50. My lord, now we the petitioners, my lord, is below this cutoff mark because, my lord, our merit position has been enforced upon or overlapped by this mathematics, my lord. If they were not in our, my lord, contest or, my lord, competition, then this cutoff mark could have come much below and we could have get entry into the, my lord, on merit.
This is unreserved.
Case,
this is unreserved.
My lord. This is unreserved. Yes, my lord.
72.50.
72.50 is the unreserved, my lord, and this reserved category is 57. Then, my lord, STP 46, OBC, MOBC 66, 25. Now, my lord, may kindly turn to the mathematics, my lord. Mathematics.
Petitioners belong to unreserved.
They are unreserved, my lord. My lord, this is for the graduate teacher science. Surprisingly, my lord, below 4, that is the graduate teacher mathematics. SM is, my lord, may kindly see.
48.
My lord, the cutoff mark for it is only 48. It is only 48. My lord, these mathematics persons or having the specialization in mathematics honors, my lord, they and their cutoff mark is only 48 million. Now in the TETCOM recruitment, though they below us, but now getting the advantage in here, their cutoff mark is due to this, their inclusion in the graduate teacher science, this cutoff mark has shooted up, So that is, our primary basic grievance, that these persons, those who has the mathematics category, those who has already applied for the mathematics category, they should not be allowed to come in, our category and take double advantage, That is our primary case,
So as of now, what is the position?
Position, this is the final document verification has been done. Now the merit list will be coming very shortly, and there will be appointment exercise will be going on, And we have also made a
Any timeline given in the advertisement or addendum?
timeline that no, that timeline in the advertisement was not there, but my respected Advocate General can apprise that when this process is going to be finalized. And we have also made a representation, by agitating our all grievance, before the Director of Secondary Education also, And this representation, though acknowledged on 16th of August, till date, they are sitting silent, no action has been taken. And on the other hand, this process is going on,
There's a speaking order here. 118. Speaking order. What is this?
Now, they have come up with another speaking order also, at page 116. This is also not in connection with us, This speaking order is only, in respect of this, honors maths degree holders, Clarification on the eligibility criteria for the post of graduate teacher mathematics. Kindly turn to page 116,
Yes, I'm on 16
This
only.
is a speaking order on 4th of July 2025. Clarification on the eligibility criteria for the post of graduate teacher mathematics as provision, the Assam So-and-so rules of 2024, whereas it has come to the notice of the government of Assam in the Department of School Education regarding confusion that has arisen in respect of the interpretation of the pairs physics, chemistry, or biology, specifically whether it requires the candidate to have studied any one of these subjects or more than one. The provision is stipulated in the amended Schedule 3 of the Assam Secondary Education Provincialized School Service, Third Amendment Rules 2024. The following proviso is inserted and read as, provided that a graduate teacher mathematics shall have a graduation degree in science with honors or major in mathematics and with physics, chemistry, or biology as a pass course or minor subjects at the graduate level, or postgraduate degree in mathematics from a recognized university with honors or major in mathematics and with physics, chemistry, or biology as a pass course or a minor subject with at least 50% marks in either graduation or the post-graduation. The department had duly examined the said proviso in the rules, and it is hereby clarified that the rule clearly means that a candidate must have studied any one among the physics, chemistry, or biology as a pass course or minor subject, along with mathematics as a major or honor. The clarification is issued for compliance by the Director of Secondary Education, and the concerned Inspector of Schools is hereby schools immediately for the purpose of ongoing document verification in the recruitment process of the graduate teachers mathematics. So, my lord, this is also, this clarification has been targeted to only the mathematics category of teachers, not with the science graduate teachers. They are fully independent as per the page 45 conditions which has been notified on the day of the advertisement itself. So therefore, my respectful submission before my lordship is that, taken care of by the government very deliberately and delicately, that they can go for the mathematics category by virtue of the addendum, and they should not be allowed to come in our place, and they should be allowed to encroach upon our post. That is will be in violation of the spirit of the rule, That is my humble submission before.
Spirit of which rule?
Rules means, my lord, the spirit of the initial advertisement, my lord, which has been issued at page 60. my lord. And the rule basing on which the recruitment process had been initiated. my lord. And my lord, in fact, this mathematics honors, my lord, originally it was not in the rule, my lord. Of those person who has the mathematics, my lord, as a pass course, they can go for mathematics post as well as in the science category. But later on, my lord, this rule has been amended, and this, my lord, for the purpose of mathematics, my lord, this special condition has been put in, my lord, that those person who has the honors in mathematics can only apply, my lord, for the post in mathematics.
See, the problem would have been, there would have been no problem
My lord,
if the science graduate was required to have honors or major in science,
my lord,
physics, chemistry, or biology.
my lord.
But the advertisement doesn't say so. It just says that you have to be a science graduate.
That is correct.
Correct.
Even if we pass course holder, my lord.
But
that
for
without
math,
any honor.
they made specifically that one has to have major or
My
honors.
lord, my
Then
lord,
only you can go for that.
my lord.
So the rules does not prevent them, does not debar them from applying for the science thing. So how can you say that
No,
this
my lord,
is
the rule, if my lord, my lord, with all respect, my lord, what I beg to submit, my lord, the rule as well as the advertisement has not distinguished or categorized the science graduates, my lord. Even person having mathematics in honors is also a science, and people like us is also a science, my lord. There is no dispute, my lord. But only thing is that when there is a special cadre had been created, my lord, for the purpose of those persons, my lord, who are having the honors in mathematics, they can go for the mathematics subject. But now for people like us, my lord, there is only one area is left, my lord, that is the science graduate, my lord, general teacher science. Now, these person are having been, my lord, giving the benefit of applying in the two posts, my lord.
no,
That
then
is
I've
the-
understood.
That
You-
is the
Okay,
difficulty. my
you
lord.
have filed your representation.
My lord, we have my lord, this is our representation
Which one?
at page 122, my lord.
This is what's in Hindi.
No, no, my lord. Some candidates who are deprived due to overlapping problem in the result for appointment of general teacher science, page 122, I am reading, my lord.
No, page 125. What is this?
No, my lord.
Oh, this is in Assamese.
This is in Assamese, my lord. Vernacular. We
Ah,
have
it's in
translated
Assamese.
it.
Correct. This is in Assamese.
Fine.
So 122 is the translation.
122 is the
Okay.
translation.
And the applicants or the representationists are total 38 numbers.
No, my lord, in the representations, there are many, but now, my lord, before my lordship, my lord, only 28 numbers are here, my lord, before
38.
my lordship.
38 representation.
Yes, my lord.
38 persons have signed the
Signed
representation,
the representation.
but
Out
only
of that,
28.
My lord, out
28.
of that 38, now before my lordship is only 28.
Yes.
About it in our school days in science, there was a phase. All alkalis are bases, but all bases are not alkalis. It is a classic case. Those who are having mathematics, they can apply for both mathematics graduate teacher as well as science graduate. Those who are not having mathematics, they are having graduation degree with some other science subject. They are eligible to apply only for the graduate science, not for math, because they do not have mathematics. If I have mathematics, I can apply for both math as well as science. So that is the situation. If we look at the addendum, page 56, the first advertisement was issued on 26th of December 2023, and thereafter everything was lying idle, and no date was given to submit a application form. So on page 56, that is the date will lordship will find at page
Bottom,
page 58. The
1610.
Addendum date is 16th of October 2023.
Yes.
24. And here, lordship will see how to apply Roman 2. The online application will be accepted from 21st October till 15th of November.
See,
So,
Mr. Saikia,
Lord,
I think facts broadly and there's no, it's clear, facts are very clear. Only thing the petitioners are saying that this has curtailed their right under Article 14 and 16.
how can that? That is why I'm coming. So advertisement was issued. The submission of application was 21st of October till 15th of November when this addendum was issued. And the most important part here, that second paragraph. Further, minimum educational and professional qualification for direct recruitment in the post of graduate teachers mathematics will be as such. 1. Graduate teacher mathematics shall have the graduation degree, etc. etc. So for mathematics graduate teacher, the qualification has been prescribed now in the advertisement. And prior to this, on 23rd of August 2024, an amendment was done. That amendment, lordship will find amendment page 115.
Amendment of?
Amendment of the rule. Assam Secondary Education Provincialization School Service Rule 2018. This vital factor is not placed here by the learned senior by the learned council during the present proceeding. So here, amendment of Schedule 3. In the principal rules in Schedule 3, the clause 2 is the last line for the punctuation appearing at the end of punctuation mark shall be substituted and therefore the following proviso shall be inserted. Provided that a graduate teacher mathematics shall have a graduation degree in science with honors or maths in mathematics and having physics, chemistry, biology as past course or minor subject in graduate level courses or postgraduate degree in mathematics from a recognized university with honors or major in mathematics having physics, chemistry, biology as past course or minor subject with at least 50% mark in either graduation or post-graduation. So this was the amendment brought in the month of August 2028 before the addendum was issued. So whatever is inserted in the addendum, lordship, in the advertisement, which is the part of the advertisement, was on the basis of the rule. And this rule was challenged by the same petitioner with the same council before the division bench. Petitioner is different, but the council is same. And the Honorable Court only simply issued notice. There was a prayer that the advertisement should be, the recruitment proceeding should be stopped. Because according to them, there is a change of rules of the game once the recruitment process started. The Honorable Court did not accept that argument and simply notice was issued. So whatever we are doing, it is as per the prevailing rules and regulations. The rules are statutory rules, 309 rule. We cannot violate and give any relaxation. All the candidates who are having mathematics, they can apply for both mathematics graduate teacher or science graduate teacher. But all the persons without mathematics with other science subjects, they can apply only limited to the post of graduate science teacher. So there is no infirmity in respect of the persons who are considered for both the categories of post, subject to the condition that they fulfill all the requirements as per the amendment of 23rd August 2024. This amendment has entitled them to apply for mathematics as well as graduate. Now, when they have the present stage, the verification is going on regarding these two categories of persons who have applied for mathematics. And what we have done, may I read the written instructions I have received. During the time of physical verification, the candidates who have applied and qualified for both the post of GT, that is graduate teacher science and graduate teacher mathematics, have been given choice of preference and accordingly 2 or more lists showing cutoff mark for the post of graduate teacher were published. And as per cutoff, place candidates of second and third list are called for document verification. So the candidate who is having qualification for both the posts, they were given the option to choose one. So there is no violation of Article 14. Recently, we have conducted the recruitment process for assistant PP, additional PP and PP. Some of the candidates, some of the advocates, they are successful in all the three categories, assistant PP, additional PP as well as PP. But they have to accept one. So that option is given. Here also that option is given. If you have the qualification, there is no bar, no restriction for you from applying. But you can choose only one. He cannot work in both the posts. So there is no violation. If they are not successful, that means their marks are not up to the requirement. They have failed in their cutoff marks. They are not deserving candidates. They cannot be considered on merit, not for anything else. If they have the marks, there is no difficulty. They can compete with the persons who are having mathematics. But their marks are lower. That's why they are not considered. It is not a case that with higher marks, they were deprived. They have lower marks than the other graduate teachers. I'm not bifurcating the science graduate or mathematics graduate. So we are purely going on merit. So in my humble submission, if at the base Lordship may be pleased to issue notice, we will file a detailed affidavit. But Lordship may not be pleased to pass any interim order at this stage because prima facie there is no case in favor of the writ petition. And two lists are already issued. They know who are selected, who are not selected. They are not parties on. So if something is passed by this honorable court, or at the base Lordship may issue notice with the condition that any appointment made subsequent to this advertisement will depend upon the outcome of this report. In that situation, Lordship, I have no further submission to make. But seeing the whole process, Lordship, it will upset the whole recruitment process. It is a long pending recruitment process started on 26th of September 2023. We are at the back end of the election process. Lists were published. They have not made anybody party. Their right will also be adversely affected if any interim order restraining the government from recruiting the person.
Okay.
It is very clear that they do not qualify. And for their disqualification, this honorable court may not be pleased to help them. If they are deprived or if their right is infringed upon, they do not have any violation of right. If they have the mathematics in their mark sheet, they can apply for both the posts. If they do not have mathematics, they are restrained to apply only for the post of graduate science teacher, not for the mathematics. So government cannot be attributed with any fault for their deficiency.
Okay.
This is my humble submission at this stage.
Mr. Bhuya.
My Lord, with all respect to the submission of my respected Advocate General, my Lord, what has happened? Said that we have been allowed to compete with the my Lord science graduate teacher.
Mr. Bhuya,
My
see, today is motion day. We'll issue notice, that's all.
My Lord.
Issue and subject to the outcome. This will be
My
the
Lord,
order.
subject to outcome, my Lord, then those person who is going to be appointed, my Lord, their rights will, my Lord, come in, my Lord.
Then
So,
will
Lord,
then,
my
then you don't want
interim-
subject to
my
outcome, then
limited
will not.
interim prayer is that, my Lord, they can be, my Lord, in the category of this, my Lord, science graduate may not be, my Lord, the other post they can go for, my Lord.
No.
Because, my Lord, all, my Lord, this number of posts, my Lord, wherein this present
See,
petition.
prima facie, I don't find any case for stay. To be very open. So we'll issue notice and subject to outcome, if you want, we'll do that. We'll consider it. Let them file an affidavit.
If the appointments are going to be made. my
What
Lord,
to
then-
do, what to do. See, you're not being deprived. You
But
have
my lord,
apply
they-
for science.
But my lord,
If you have the merit, you will go for it,
prima facie, we have a case, my Lord. Prima facie, we have. a
according to
case.
you. But according to the court,
No, my Lord,
there is no such.
no, my Lord, we have to, my Lord,
Article 14 cannot be said.
Take the order.
my Lord, we can only pray, my Lord, we can only pray.
Heard Mr. A.R. Bhuya, learned
Well.
counsel for the petitioners, who submits that the petitioners are aggrieved with the opportunity given to the applicants for the post of graduate teacher mathematics to also apply for the post of graduate teacher science. Stop. He submits that by such an action, the chances of the petitioners who have applied for graduate teacher science has been diminished. Stop. He therefore submits that the respondents pending disposal of the writ petition should be directed to only accept the application of the applicants who have opted for graduate teacher science for filling up the post of graduate teacher science. Or otherwise, the rights of the petitioners as guaranteed by Article 14 and 16 of the Constitution of India will be infringed. Next para, Mr. D. Saike, Learned Advocate General, Assam. On the other hand, submits that there is no bar for the graduate, for persons having degree in science with honors or major in mathematics and also with other science subjects to apply for the post of graduate teacher science. Stop. He submits that the initial advertisement dated 26/12/2023 did not provide for the timeline for submitting the application, and the same has been duly clarified by the addendum issued on 16/10/2024. Stop. He submits that this in fact was pursuant to the amendment made in the Assam Secondary Education, open bracket, Provincialized Schools, close bracket, Service Rules 2018. By the Assam Secondary Education, bracket, Provincialized Schools, close, Service, open bracket, Third Amendment Rules. After amendment, close the bracket, Rules, 2024, which was notified in the Assam Gazette on 11/9/2024. Clearly specifying the requisites for those who aspire to become a graduate teacher in mathematics. Stop. He also submits that despite two options given by those having their major or honors in mathematics, they are to exercise an option if they are found successful as to whether they would like to opt for graduate teacher science or graduate teacher mathematics. Stop. As such, none of the fundamental rights as alleged is being violated. Next para, in view of above issue notice motion returnable by 4 weeks. Mr. S.M.T. Chisti, learned standing counsel. Secondary education accepts notice on behalf of the respondent numbers 1 and 2. On behalf of the respondents, only 1 and 2 only. On behalf of the respondents, as such, no formal notice is required. Petitioner shall furnish requisite copies of the writ petition to the learned standing counsel within 2 days. This again after 4 weeks.
If any appointment is made.
You want that? You said you didn't want that.
No, my lord. My lord.
Okay.
At least for something.
It is also provided that any appointment made to the post of graduate teacher,
Science.
science, in the meantime, shall be subject to the outcome of the writ.
My lord. Hello. Lord, deep love. Here, your lordship, yesterday,
Yesterday,
this case is squarely covered by order dated 15/9/2025.
so what is the case?
Your lordship, detail order has been passed. Point, Calicut. Record.
Covered by which order?
Lordship,
Covered by which order? 15/9.
15/9.
But this is not a disposal order, isn't it?
No, your lordship, not a disposal and notice has been issued.
Only
Your
notice
lordship.
has been 2 weeks.
In my case, your lordship, this case, your lordship is slightly different. In the, your lordship, yesterday I have pointed out, your lordship. Your lordship may kindly.
Just a minute, huh? Mr. Botaku.
These are your lordship postgraduate teachers. Your lordship.
Yes, what is your grievance?
This case, your lordship, is lordship. The order they have, your lordship, submitted, your lordship, to this honorable court. They are your lordship graduate teachers, your lordship. And here, these are your lordship postgraduate teachers. There are 20 odd candidates, your lordship. That advertisement, your lordship, has already gone through, your lordship. Now, your lordship will kindly see, in this case also, there was an addendum issued, your lordship, at page 40. And page 40, your lordship.
Where is the original? This
Your
one,
lordship,
34.
original advertisement, your lordship, will
34.
get it at page 28.
This is for PG. The other one was graduate teacher.
Correct. And item 15 is for your lordship, graduate mathematics science teacher.
This one is for
Postgraduate,
graduate PG in what?
postgraduate teacher,
In which subject?
in different subjects. The
Or different
petitioner-
subjects?
Different subject, your lordship.
Huh.
Assamese mostly, and then your lordship English, and your lordship political science, English, history, Bengali.
Okay, so what is your case?
Now your lordship will kindly come to page 40, your lordship.
40,
40,
addendum.
addenda.
The first advertisement was there. In the addendum, your lordship, there is a your lordship. They have mentioned the vacant post, your lordship. And then your lordship will kindly come to page 42. Serial number 12, your lordship.
Page 42.
42.
Yeah.
Serial number 12, which says your lordship.
Yeah.
First part, your lordship, I am skipping your lordship. For verification of qualification and other particulars of the candidates, a draft merit list will be published. Your lordship will kindly note the wordings with a ratio of 2 candidates against one vacancy. Thereafter, after verification and final merit list will be prepared from the draft merit list as per the outcome of the verification report and as per the merit in the draft merit list in the ratio 1:1. Initially, they have said that it will be 1:1, your lordship, in the initial advertisement. Then, your lordship, at page 42, by this addendum, they have said that they will publish, your lordship will kindly note those words. They will publish a draft merit list, your lordship, with a ratio of 2 candidates against 1 post. Now, your lordship, what they did, your lordship, no such, your lordship, list was published, your lordship.
Draft is 2 candidates
Lordship.
against 1 vacancy.
Vacancy, your lordship.
In the final list, it's 1:1.
1:1. Now, your lordship, 2:1 for your lordship for verification. Your lordship. Now, your lordship, they have, your lordship, already called people for verification. Now, while calling for verification, no list as per this advertisement they have published. No, we have not even been your to call for verification. Your lordship will kindly see they are specifically mentioned that purpose of verification.
You have not been called for verification.
No, we have not been called for verification, and they have.
Okay, who are qualified to be called for
That
verification?
they have, your lordship, informed the candidates, your lordship, and they have, your lordship, first round of verification is complete in the month of, your lordship, July itself. July itself.
No. My question is that who are those who are qualified for verification?
That, your lordship, they have not disclosed.
Any
to us.
criteria?
That, your lordship, page 64, your lordship, cut-off mark, your lordship will get. Page 64, they have published this here, revised cut-off mark for so-and-so, postgraduate teacher. And these are the cut-off marks, your lordship, for different. Those, your lordship, we'll have to presume that, your lordship, that those who have been above this cut-off mark, they have been
called.
They called. But there is no select list, number 1. And to our knowledge, your lordship, it is not 1:2, your lord. 1 post 2 candidates. It is, your lordship, 1:1. 1 candidate for 1 post, they have called for verification. Now, the point is, your lordship, during verification, your lordship, your lordship has dealt with some cases, your lordship, where your lordship, for various reasons, your lordship, after verification, candidate selection was, your lordship, the candidate document, after document verification, some of the candidates were rejected, your lordship. Now, when those were rejected, your lordship, for example, your lordship had dealt with 2 cases, your lordship. One relating to your BH certificate, your lordship, and one relating to your lordship. Assamese diploma certificate. Those candidates who have not cleared, your lordship, who have not cleared their eligibility criteria on the last date of application, like this one, those were rejected, your lordship. Now, when those were rejected, your lordship, the necessary corollary to that would have been, your lordship, to call other candidates or a second list for verification, your lordship. So far as the graduate teachers are concerned, your lordship has dealt with right now, your lordship. They have published 3 lists, your lordship. After first round of verification, some candidates were rejected. Then second list was issued. And in the second list also, some were rejected. Then third list was issued, Your Lordship. Here is a case, Your Lordship, where they have not done that exercise. Your Lordship. Ultimately, Your Lordship, had they issued published the merit list, Your Lordship, as per the terms of the addendum, Your Lordship, terms 12 of the addendum, page 42, Your Lordship, these issues would not have cropped up, Your Lordship. And to make it transparent, Your Lordship, the advertisement has clearly stated that there will be 2:1, Your Lordship. And on that count, Your Lordship, when I pointed this out, Your Lordship, yesterday, Your Lordship, day before yesterday, Your Lordship, the Learned Standing Council, Your Lordship, Education Department has said that you will take instruction of that, Your Lordship. And that is, Your Lordship, by going, Your Lordship, that by changing, Your Lordship, this going beyond, Your Lordship, or violating the terms of advertisement, they have acted arbitrarily, Your Lordship, in my humble submission, and in a very non-transparent manner. And at the end of the day, Your Lordship, it is a case of a public employment, Your Lordship. There are, Your Lordship, there must be a, Your Lordship, transparent manner of, Your Lordship, selecting the candidates, Your Lordship. And that will be fulfilled only when, Your Lordship, they will come up, Your Lordship, once select list is published, our names are not there, then matter ends there, Your Lordship. If, Your Lordship, select list is not published, they are calling people, Your Lordship, individually. I am not saying that they are not beyond cut of date, but even then, Your Lordship, there should be, Your Lordship, a select list, general select list published in their website. That is not there, Your Lordship, to my instruction, Your Lordship. And, Your Lordship, therefore, Your Lordship, this all has come up, and they have, Your Lordship, the against rejected candidate, they should have called for, Your Lordship, other candidates, Your Lordship. That has also not been done, Your Lordship. That is why we are before this honorable court. And on that, Your Lordship, if they say that the verification process will continue, press list will come up, Your Lordship, the matter ends there, Your Lordship. If that is not there, Your Lordship, why they have not followed this, Your Lordship? Some explanations from their part, Your Lordship, is to be there, Your Lordship. And Your Lordship will kindly see our marks, Your Lordship. I have mentioned it in page 16, para 9, Your Lordship. Page 17, Your Lordship. Cutoff is, Your Lordship, 65.75. I have got 63.7.
Lesser than cutoff.
Lordship, cutoff, just below the cutoff. And that's why we are apprehensive that Your Lordship, in the process, Your Lordship, we are being deprived, Your Lordship. This is precisely our case.
No, see, since you have not received the cutoff, you have not reached, secured the cutoff marks. That is why you will not call for the
No, Your Lordship,
verification.
that is not the case, Your Lordship. What is, Your Lordship? This cutoff, Your Lordship will kindly see, Your Lordship. These cutoffs, Your Lordship, is based on, Your Lordship. This cutoff is based on, Your Lordship, 1:1, Your Lordship. It is not that they have fixed a cutoff, that this will be the cutoff, and above this cutoff will be called, Your Lordship. These cutoffs are based on, Your Lordship, the marks secured, Your Lordship, and 1:1 basis they have called the candidates, Your Lordship. Based on that, Your Lordship, that is why, Your Lordship, will kindly see, Your Lordship, in graduate teachers, cutoff has changed, Your Lordship, along with the change of, Your Lordship, list, Your Lordship. In the first list, there is one cutoff. In the second list, there is one cutoff. That's the case. Ultimately, Your Lordship, if they show, Your Lordship, that there is a list in which, Your Lordship, on 1:2 basis, they have called the people for interview, Your Lordship, for document verification, Your Lordship. Whether that they have followed it or not, Your Lordship.
This draft merit list is based on what?
Draft merit list, Your Lordship, apparently, Your Lordship, that is, Your Lordship, for verification, Your Lordship. Only after verification. That is why, Your Lordship, will kindly see, for verification of qualification and other particulars. Page 42.
No, what I said was, what is the basis of preparing that draft merit list. It is based on the cutoff marks.
That is, they have not disclosed that, your lordship, in the advertisement, your lordship. They have not stated so in the advertisement. None of the advertisement.
So we'll ask Mr. Saikia.
Lordship,
That is your case.
Lord. This is my case.
Lordship, there is a cutoff mark, and accordingly, the persons who are called for verification, who are those who are in the cutoff. They are not falling into that cutoff mark. They have not qualified.
How is
They
that?
have
How is that cutoff mark made?
cutoff mark is made, Lordship. There was a test, written test had taken place in the month of January.
No, how is it?
And also say
How is it fixed? The cutoff marks. How is it
that
fixed?
instructions I have to take, but in the earlier case, the submission was that the present petitioners did not qualify in the first. So same is the situation here.
Did not qualify in the?
First list, at least one list was out.
Ah.
So they are not coming up with complete facts. So my case is, I have received some instructions today, which says that the process of verification is still continuing, number one. The final select list will be published once the process is over. Now, is he projecting a case that his mark is X and a person X minus 1 is given? It's not his case. His own submission is that he did not fall within the cutoff mark, or the mark which is given, he comes below that. So what exactly is the grievance? I am still not being able to understand. I do not know the situation, Lordship. What exactly is his problem? The problem, what he wants, Lordship, if Lordship is pleased to look at the prayer. What exactly was? I am going to consider all the prayers right now, right here. What is his first prayer? Page 25. So his first prayer is that directing the respondent also to publish second cutoff list, since many of the candidates are being rejected in the first round of verification of documents. Why he is concerned? It is not a public interest litigation. Somebody were called and somebody were rejected in verification or whatever. How he is bothered? Number two, directing the respondents also to publish the rejected list of candidates showing their ground after of verification of documents. Those who have been rejected, they are given a rejection slip right at the place. I have the copies. The other day I have placed the copies also. The ground of rejection is given at the moment when it was rejected. Number three, player, direct the respondent authorities to eliminate those candidates whose name appear in both graduate teachers as well as postgraduate teachers, and to call new documents for verification. What are these pairs? Right now I'm conceding, Lordship. We'll publish whatever is required. Lordship will not give us a timeline because our team is fully busy with making the final selection. Lordship will give us 4 weeks and all these data will publish. Right now, Lordship may be pleased to dispose of the. And same pair was, if Lordship is pleased to look at the judgment, the order which I have taken. Paragraph 2. Same pair. If one is postgraduate teacher, one is graduate teacher. Paragraph 2, may I read it? In this petition under Article 226 of the Constitution, the petitioners have prayed for issuing direction to the respondent to publish the reject list of candidates showing the ground after each stage of verification. Same prayer here. Issuing direction to the respondent authorities to eliminate those candidates whose name appear in 2 different subjects and to call new candidates for document verification in their places. Issuing direction to the respondent to fill up remaining 13. This is a imaginary figure from where they have got. So I do not know. Now, Lordship, may I read the whole judgment? Paragraph 3. Mr. Borthak, learned counsel for the petition submitted pursuant to the advertisement dated 26/12/2023, issued by the Director of Secondary Education. The present petitioners had applied for appearing in the teachers eligibility test cum recruitment test for the post of graduate teachers, art in Assamese medium. Thereafter, on 19/1/2025, they, along with others, have appeared in the PET, and on 23/6/2025, the results were declared. But the present petitioners did not qualify in the first list. So list was there. So what list they are now talking about, I am not understanding. That's why I'm saying I'm a little confused. This is the petitioner's submission.
further submission of Board Thakur is that the advertisement, it was clearly stated that preparing stream-wise separate merit list for graduate teachers, but subsequently SOP dated 27/5/2025 was issued, wherein it is stated that after completion of the verification process, the zonal inspector of schools will prepare a list of candidates who have been rejected showing the ground of rejection. So after completion of verification process, their submission. And that is as per the SOP. And my submission is that verification process is still continuing. So it's a premature case. Who have been rejected showing the ground of rejection against each rejected candidate. In fact, my instruction is that I have a copy also. The rejection slips are given showing the ground of rejection to all the candidates. Mr. Board Thakur further submits that though a specific provision was made in SOP dated 27th May, yet in the instant case during verification process, number of candidates were rejected or for various reasons, like not having qualification criteria on last date of application, for submitting false certificate, and against such rejection till date no list has been published. So the slip is given, but the list is not published. That is his demand. Has been published by the authority. Being agreed by such action on the part of the respondent authorities, the petitioners have preferred his petition with the above mentioned relief. Per contrast, when so appearing for the respondent submits that the relief claim it is petitions are not clear, and the petitioners have no locus to file this present petition, which is obviously not a public interest litigation. And that as per the instructions received by him, applications of some of the petitioners have already been rejected, and the individual letters have been issued to them by showing grounds of rejection, and that this petition is filed with malafide intention to halt the entire selection process. Under such circumstances, so and so submit that this petition may be dismissed in limine without being notice. The other day I submitted a rejection slip. The submission so advanced by so and so council needs further consideration. At this stage, notice be issued to the respondents within week from today, returnable 2 weeks. As learned AG Assam has appeared and accepted notice, all the states no formal notice is required to be issued. However, extra requisite copies of the petitioner be furnished to him during the course of day. Please the matter after 2 weeks. In the meantime, instructions so received by learned AG shall be brought on record by filing affidavit. So today also, I have received the instruction. So I may be allowed to file any. But till now, the case is not clear. And it is premature in my humble submission. An individual, it's a serviceman. What individual right has been infringed and how he is aggrieved, that has to be first projected before the honorable to make out a prima facie case. Just saying that this is not done, that is not done, how he is bothered? We are following the SOP as well as all the rules and regulations in true letter and spirit. Once the final list is out, he has all the right to point out that if any undeserving candidate is selected. What is his interim prayer? Stall the proceeding. So what is the intention? And that is why I'm considering all the main prayer right now. There is no difficulty in accessing to any of the prayers. Nobody is hiding anything. Everything is going very transparently, and his own submission is that, Lordship, I do not come above the cutoff mark. That itself is the end of the story. No further submission is required. If you are not qualified, you should not be bothered about what the government is doing and who is getting the selection process. He does not have a locus standi to challenge this proceeding on the basis that he does not have the requisite mark. So he is not a qualified candidate to participate any further in the ongoing recruitment process. So my humble submission that if possible, Lordship, maybe please impose cost on the petitioner. These are frivolous petitions. Just to solve the recruitment process. That is why Lordship is pleased to go to the interim prayer. May I please that interim prayer? Now, page 26. It is further prayed that pending disposal of the writ petitions, your Lordship may be pleased to direct the respondent authorities not to publish the final merit list. That means he wants the selection process to not proceed any further. Until now, we are in the stage of preparing the merit list. Once that merit list is out, then the cause of action, whatever may be the cause of action against each individual, that will come up. But at this stage, when the result is not declared, merit list is not prepared, it is under process, it is in a fluid situation. In that situation, nobody can say that my right has been increased. If he is agreed that he has not qualified by the cutoff mark, then he has a case, but that is not the case projected. He wants the list of the rejected candidates. Yes, Lordship will give that list.
What about this prayer number 3?
I do not understand, Lordship.
Eliminate candidates whose name appear both
No,
in.
that is the previous case. One is graduate teacher science, one is graduate teacher mathematics. So eliminate one. That is the, if I am not wrong, that may be the intention. But any person who will be selected, he will get only one, he will not get two. Suppose a person has applied for postgraduate teacher as well as graduate teacher, like the present case. The person, according to him, you allow one person for one post only for the purpose of recruitment. What we are doing, we are allowing everyone to participate in the recruitment process, but for appointment, you will be given only one post. There is no bar from you to apply for all the posts if you have the qualification, eligibility criteria. He wants to indirectly, Lordship, remove some of the qualified persons or eligible persons from participating in the recruitment.
Okay.
So everything becomes very complicated, but it is simple that there is no case at all, no prima facie case has been established, and no individual right has been infringed. This is my humble submission at this. Only notice may be issued. I have received written instruction, I can file it. And if Lordship is pleased to dispose of the petition by allowing all the prayers, except the last prayer, I am ready for that also.
Lordship, so far is a Lordship.
Just one second, Lordship, these are the rejection schemes. So we have to compile all the persons whose names are in the rejection category. We place it on the other day. Verification started, rejected verification for graduate teachers signed. She has obtained SME's diploma after the cutoff date, that is the round of rejection.
These are given individually. It's not
All
aggregate.
individuals.
Lordship, that has been given individually, and my case is that, Your Lordship, once that person has been rejected, Your Lordship, where is the other person, Your Lordship? Against that post, Your Lordship. That is precisely the case, Your Lordship. They have rejected someone against that post, Your Lordship, against that person, someone else will have to be called, Your Lordship. Why are you not calling that? And when, Your Lordship, my right, Your Lordship, comes, Your Lordship, when you violate your own advertisement, Your Lordship, where is that list? I have made this, Your Lordship, that list is not there. That list, Your Lordship, which they are required to publish, Your Lordship, 2:1 basis, Your Lordship, 1:2 basis, Your Lordship, that has not been published by them, Your Lordship. That is my case. And secondly, Your Lordship, this was important. Had they called 2 persons, Your Lordship, against one vacancy, once, Your Lordship, against that rejection, the other one would have remained, Your Lordship. And we would have come within zone of consideration, Your Lordship. That is our case, Your Lordship. That should be answered, Your Lordship. My locus, Your Lordship, I am a candidate, Your Lordship. I am feeling that the action of the authority is arbitrary. That is why I am before this honorable court, Your Lordship. And there is no malafide, no malice, nothing else, Your Lordship. The candidate authority has not followed their own advertisement, terms of the advertisement. That is why they are before this honorable court. By only making prayer, can it be inferred that that is out of malice, Your Lordship? These kind of statements, Your Lordship, highly, Your Lordship, objectionable.
All right, we'll issue notice.
Lordship.
Heard Mr. S. Botago, learned counsel for the petitioner. Submits that the petitioners have applied for the post of postgraduate teachers
In
different governments, secondary schools, in different subjects, in terms of the advertisement dated 26/12/2023 and the addendum dated 16/10/2024. Stop. He submits that the petitioners have not been called for the document verification, which leads them to understand that they have not secured the minimum cutoff mark. So I'm referring to the instructions in the form of additional information at paragraph number 5 of the addendum dated 16/10/2024, comma, he submits that for verification of qualification and other particulars of the candidate, comma, a draft merit list will be published with a ratio of 2 candidates against 1 vacancy. But thereafter, upon verification, a final merit list will be prepared from the draft merit list as per the outcome of the verification report and as per the merit in the draft merit list in the ratio of 1:1, page 42. Okay. So, however, the respondents have not published the draft merit list. And the candidates and the list of candidates who have been rejected. Next para, in view of above issue notice, motion returnable by 4 weeks. Mr. S.N.T. Chisti, learned standing counsel, secondary education. Accept notice on behalf of all the respondents. As such, no formal notice is required. Petitioner has responded requisite copies of the petition. Within 2 days. List again after 4 weeks.
Lordship may fix a date, your lordship, after immediately after vacation. Because in the meanwhile, result will be out and your lordship appointment.
Respondents to file the counter affidavit in the meantime. Give a date. Mr. Saikia, when can you file affidavit? He instructs whatever.
Within a week, that maybe by Friday with filing.
In that case, your lordship may fix it on 13th, your lordship.
23/10.
If we fail day after tomorrow, then during the vacation period, we'll file it when the office is open. We'll give an advance copy to them. So,
You have it on 13?
13th.
30. What about the other case?
other
Good.
case has given 2 weeks time.
2 weeks time.
So, this case may be tagged along with that. Because the issues are.
Is that your lordship postgraduate teachers and those are graduate teachers?
You are the counsel in that case. This is the matter along with the petition number 5370 of 2025. That's it.
I know. These matters may. If the policy is published today at morning, or say we couldn't follow it and we couldn't bring a record of it.
What was
Tomorrow,
this
your
matter?
lordship, tomorrow, Friday will be, Friday, your lordship, it will be a last 4 day, your lordship. Tomorrow, your lordship. Your lordship has already heard my part, your lordship has recorded that also. Tomorrow, your lordship.
Any difficulty tomorrow? All right, tomorrow then. As paid for by the parties, this is the matter in tomorrow. Both 1 and 2 together. I think 6. 26. What is this matter?
It's a stay advocating application. The document kindly come, this is regarding recruitment to the post of principal of the college. If your lordship would kindly come to the interim order, which was passed at page 16 of the IA. One thing. Let me read your lordship.
Yes.
Start at page 18.
Read.
Learned counsel for the petitioner who submits that the petitioner responded to the advertisement dated 27/2024 for the post of principal of Gornagar College, Korpuk, Borpeta, Assam, and the manner in which selection is to be done has been prescribed in the advertisement itself and also by the Assam College Employees Provincialization Amendment Rule 2017. While the process of appointing suitable candidates to the state post in question is being processed, the petitioner sought for certain information regarding the recommendation being made for filling of the said post and has come to learn that the private respondent number 9 has been selected, but the private respondent number 9 was found to have submitted 2 clone journals, and therefore the governing body of the college declined to accept the recommendation made in favor of the respondent number 9, that is me, by the constituted selection committee. The learned senior counsel submits that at any rate the matter has been submitted to the Director of Higher Education for further necessary action, and the petitioner apprehends that the private respondent number 9 could be selected and appointed despite having 2 clone journals. Hence, the petitioner has filed the writ petition. A notice was issued, and at the very last para at page 19, your lordship, status quo was granted. Thereafter, I have entered appearance and kindly come to page 14, that is the advertisement. One clause.
Just a minute. Selection committee had given the recommendation.
Yes.
But the governing body declined.
Yes.
That is the case.
The resolution has been adopted with regard to what's happened, your lordship. They say that I have submitted 2 clone papers. The advertisement dictated that I have to submit 10 publications. Now, out of that, 2 are cloned.
2 are cloned.
However, what happened is actually I submitted 13 papers. Out of 13, my lord, even 2 if considered to be clone papers, 11 remains. 11 remain. So that decision, that particular decision, there was a disconsent from 13 members that has been recorded and has been forwarded to the director.
But where is that? That he had submitted 13. John.
My lord, in the reply given to my IA, that is the reply to the RT application by the petitioner, I am the private. And at page 46, serial number 46, that is the affidavit opposition filed in the IA.
Page 46.
Page 46. This is the reply to the IA, and if your lordship would kindly come to page 47, serial number 4, Parag Bormon. Serial number 4, Parag Bormon, that is me, man. Now, if your lordship would kindly see the row that is publications. Page 4. Publication.
Yes.
There against my
my name, your lordship will see paper publication, peer reviewed 10.
Hmm.
Other publications with ISBN 3. So even
Is it repeated? Are the publications repeated twice
repeated twice.
with ISSN?
Yes.
Again,
that-
3.
That is repeated twice. So 13. And even if I can take your lordship to my biodata, I have submitted 13 papers. Now, all of these have been recorded, and in the same affidavit, I will take your lordship, that particular letter is there, which has been.
Today, what are you seeking for?
I'm seeking a vacation of the stay order. And also, lordship can dispose it off on the ground that the writ petition is premature, because the selection committee has forwarded all of this discontent and whatever they have expressed against me, against my selection, to the director of higher education for taking final decision. Now, the law is clear. The rule provides that the director is the person who is going to finalize the entire selection process.
Where is that? Forwarding?
Well,
Selection committee or the managing committee?
well,
The governing body.
the
It has to be routed through the governing body. So who has sent it?
well, the
Governing body or the selection committee?
I have said it.
Where is the sending of the thing?
Well, the page 44. Lordship has seen 47 right now.
44.
So to the Director of Higher Education, forwarding of governing body meeting resolution 2 dated 5/6/2025. These are the 2 clone papers which have been pointed out against my selection.
If I really participate here, rather than going into this, but here submitted, there are judgments that when it is pending before the director of higher education, that the state petition may not be local.
You are agreeable?
I am agreeable to send it to director. Director will hear the both the sides and pass it. That is the subtle position your lordship therefore are going on very.
Heard, Mr.
P. Bharadwaj.
P. Bhardwaj, learned counsel for the applicant. And also Mr. S. Bhotakur, learned counsel for the
Rate petitioner private.
respondent number.
Petitioner opposite.
Respondent number in the IA.
In the IA 1.
Respondent number 1 / writ petitioner. Stop. Also heard Mr. P. Mohanta for respondent 4, 5. Numbers 4, 5, and 6. And Mr. S. Bhuya, SC Higher Education for respondent number 2 and 3. And Miss K. Bor Pujari, learned counsel on behalf of Mr. A. Sonwal. A. Shamua, standing counsel, UGC. Are how many of you are appearing? And Mr. J. Patwari for respondent number 7. IA. Next para. Have you got it? This IA is filed seeking vacation of the interim order dated 28/7/2025, passed by this court in WPC number 4187 of 2025. By which the parties have been directed to maintain status quo. As regards the selection and appointment for the post of principal,
Barnagar College, Sorbhok.
'Barnagar College, Sorbhok. Next para. In the writ petition, it is the case of the writ petitioner that out of the 10 journals submitted by the respondent number seven,
In the main writ petition, I have 7.
oblique applicant in the IA, comma, 2 of the journals were found to be clone, CLONE, clone journals, and for which reason the governing body
The principal has forwarded it.
declined to accept the recommendation made in favor of the said respondent or the post in question. What was the cause of action in the writ petition? The
It was forwarded to the director and he was apprehending that the director would pass an order and I will that apprehension.
but the forwarding is here already, isn't it? Again,
It's there, because that's page 44 of the I.
because of this forwarding letter.
Yeah.
However, despite the same, since the principal in charge of the college had forwarded the recommendation made in favor of the respondent number 7 to the Director of Higher Education, the writ petition was filed by the writ petitioner. Next para, Mr. Bahadur, learned counsel submits that the respondent number 7 in the writ petition is the instant applicant in the IA, and that two of the journals may have been found to be cloned, but the fact remains that the applicant had submitted as many as 13 journals. And therefore, even if the 2 journals are not to be accepted, the applicant would still be eligible to be selected for the post, to be appointed to the post.
To that, Your Lordship, I have a counter in my ticket. That noted. That is at page 37. My application.
37. Next para, Mr. R. Potthakul, learned counsel for the writ petitioner, however, submits that
That is the deponent information obtained under RTI Act ascertained that although the applicant claimed 13 publications, 3 of them were not considered by the committee, leaving only 10. Furthermore, out of these 10, 2 were found to be duplicate.
submits that the writ petitioner highly disputes the contention of the applicant in as much as out of the 13 publications submitted by the applicant, only 10 of the publications were considered top. Further, out of the 10 publications considered, 2 of them were found to be duplicate and clone papers. Next para, while the dispute lie as indicated herein above. The fact remains that the matter currently is with the director of secondary, is it? Higher education for consideration. And the learned counsel for the parties submit that such being the position, court may not decide the issue at this stage, but leave the matter to the director of higher education for consideration and decision. Since the state authority would be the appropriate authority. Under what provision?
There's a precedent of this court matter.
So apart from the decision, it must be based on something.
Yes, everything is,
What is the rule?
Rule 5.1 and Rule 7 of 2010.
Where is it mentioned?
It starts at para 11. However, the document could find at para 12, second paragraph. Paragraph 12, second paragraph. Therefore, from
Provincialization rules, 2010.
Yes.
In terms of the relevant provisions of the Assam College Employees bracket Provincialization rules, 2010. Good stop.
This is the authority which says that the director is the government.
In support of the submission, the attention of this court has been drawn to the case of Mrinal Kumar Bora, bracket doctor, versus State of Assam and others, 2017, 1 GLT 737, rendered by a court in bench of this court. In regard to the above submission and having regard to the fact that the director is seized with the matter, the writ petition is disposed of. No, the IA as well as the writ petition is disposed of by directing the director higher education to consider and dispose of the to consider and dispose of the recommendation so made by taking appropriate decision in accordance with law. Any chance to be given?
Hearing may be given.
By giving an opportunity of hearing to the parties concerned. Any time frame? Anyone? Time frame? The same should be done 2 months, within a period of 2 months from the date of receipt of a certificate copy. The interim order, what about the interim? Interim order passed earlier.
Remain till then, till director takes.
Shall abide by the decision to be taken by the director.
If you.
Public.
Your Lordship may kindly peruse the last order dated 22. dated 22/8/2025.
Yes, is it covered?
My lord, it is covered. This is the order, my lord. In my case, my case is to be placed before the DLC. And in this case, the matter was supposed to be placed before the SLC. Only this is the difference. But in this case, in this case, petitioner father died on 34/2008. And petitioner applied on 29/9/2008.
So I think then you file your affidavit. If you say it's not covered, parties are represented by the respective counsel.
Your lordship may reduce the order, it is fully covered.
No, let us also counter which part is not covered. Let us state that.
So, not for this for the is it does that Tata took the order to the guide that order DLC has recommended them. This a certificate of 89 of the certification it comes for that order. And for now that 38 of that order that required also. So already got started for
So
now
But-
then he will file affidavit, man. We'll file it.
parties are represented by the when it is submitted that by Ms. T.T. Burman, that the case is not covered by the judgment rendered in WPC number
4/6/2020.
4C.
Yes.
But it's 288.
This one, it is whether it is covered by my lord, your lordship may kindly see the last order. It is given that whether it is covered by this order, my.
Madam, I've seen the last order.
Yes.
It says
The last-
288. You're giving me some other number.
This is the order.
That may be the order, but the order of this court, this says 288.
Yes, my lord.
You're bringing another case.
288, yes.
That's what I'm saying.
Yes.
Then why are you giving me some other number?
My lord, earlier the another order 3/4/2020.
It's not covered by the order passed by the court by judgment. By this court passed in the WPC number 288 of 2025. Disposed of 4/6/2025. Give you a pop-up. Respondents to file their counter affidavit. This again after that. Okay.
Yeah, I need 1 week time to reply the affidavit that way. Respondent number 2 has 5 days. 10 days time.
How much time? 10 days. As paid for by Mr. M.R. Kandakar, learned counsel for the petitioner. 10 days time is granted to file reply affidavit to the affidavit of opposition filed by the respondent number 2. Top next para. It is seen that the writ petition as well as the affidavit has not been authorized. So it therefore appears that the same has escaped the notice of the stamp reporter concerned. So registry shall look into the matter and put up a report. So at the same time, shall ensure that appropriate instructions are issued to the stamp reporter, the stamp reporters to look into this aspect in whenever a new petition filed. So that similar mistake do not occur. You give it to the advocate's clerk. They do it, isn't it? So you'll not be knowing it. But I found that there's nothing there. It's all blank. So let them verify.
And that is a lot. Well, the petitioner is a subject teacher in a school, a secondary school. He is going to retire next month, October 31st. Now, the difficulty faced by her is that there has been a total period of 345 days marked as unauthorized absence in her leave records. So she had applied for grant of leave for that period and for conversion of that by granting extraordinary leave, which is otherwise permissible in rule. Now, there was one round of litigation before this honorable court, and the honorable court passed an order directing the respondents to take up the case and consider case 32, pass reasonable orders there, and pass 32, case 32, your lordship may kindly see. Last paragraph, last but one. Be that as it may, without going into the aspect as to whether the representations were submitted or not, or whether it was received or not, we require the petitioner to submit a fresh representation making her claim that the aforesaid leave period be regularized. The representations should be submitted within a period of so and so much. Now, thereafter, a representation was submitted.
And what has happened to your
Now, case 38, the impugned order has been issued.
That
saying that it cannot be, the leave cannot be granted because I did not submit medical documents in support of the application, leave application. Now, the leave are for the period 2000, right from the period from 2006 and all, up to the period of 2012. Those were long time back submitted to them. Your lordship will kindly see the page 22. The typed copy is at page 21. Annexure 5. And in fact, in the affidavit filed by the government, it has been admitted that this application was filed. Page 21, your lordship may kindly see. I have the honor to forward here with 2 applications of so-and-so who has asked for leave from so-and-so to so-and-so and so-and-so to so-and-so. Well, this has been also supported by the affidavit filed by the government. Now, the leave rule says that regardless of the fact, whether or not and in this particular document, your lordship will find that the leave application was forwarded along with the requisite documents. But that was not done at that point of time. Now, the leave rule says that it can be considered by granting extraordinary leave. The effect of extraordinary leave is that, my lord, I will not get salary for this 8 period.
how much is the period?
345 days. And as per the statement given by the respondents, my lord, there is a total 92 days. There is total 98.
Now, for how many days were we absent total?
Total 345.
345. Why were you absent?
Well, these were all on medical ground.
Medical grounds.
Here.
These are all unauthorized absent.
Now they did not grant the leave at that point of time, and maybe by lapse of time, the papers have been misplaced somewhere. So they are unable to grant me medical leave on that count. So I submitted that grant me extraordinary leave instead. In fact, there is an order of
No, that will come later on. What I'm asking you is that you were absent for 345 days at a stretch or
no
different breaks.
Different spin.
And for which what was done? No proceeding drawn against you.
No, only one spell of period they granted me extraordinary leave, which I claimed to be granted as TB leave. I was suffering from TB. So they said, I asked for grant of TB leave, but they did not consider my prayer. For the period from 2006, 2007, they granted me extraordinary leave. Now, barring that, there remains a total period of 345 days. And as per the leave account that the respondents have submitted in the affidavit, my lord, there is a total credit of 92 days plus 100, there will be further 120 days, total around 218 days of leave in my credit. In their affidavit, my lord, if your lordship will kindly, yes,
92 plus 120.
yes. 98, my lord, 98. Your lordship will kindly see their affidavit, government's affidavit, my lord, at page,
218 days. But there are still some deficit.
yes. Well, that can be, instead, my lord, I made a submission before the honorable court that I can forego the salary for if they grant me leave, my lord, against the leave which is in my credit, my lord, then I'll be entitled to salary. I'm even ready to forego the salary, my lord, because unless and until the leave is regularized, my lord, my pension will be held up.
Correct.
That is
So-
difficult.
So 127 days remain.
127
Even if you are to use up 120 days plus 18, I mean, you want 120 plus 98. From out of the total 345 days,
Yes.
if you deduct 218 days, balance is 127 days.
127.
What will happen to that balance?
They can grant me extraordinary leave, my lord. The leave rule says,
No, extraordinary leave, you're asking for that period only, isn't it?
no,
Is there any limit for extraordinary leave?
in my total service career, I cannot be granted more than 500 days.
And how much have you availed so far?
Only 180 days.
180 days. So there's a balance.
There is a balance.
No balance. If it's 180.
No, this 218 is earned leave. This is still in my credit. If they regularize my absence as against this, my lord, the only thing is that I'll be getting the salary for this period. And if they don't regularize this period against the earned leave, my lord, they can grant me extraordinary leave.
Anyway, we'll have to hear this matter. Today it's not possible.
Well, if your lordship will kindly see, there is one order, last but one. I also made a submission that I can forego the
No, I
salary for
understand.
this period.
I understand. To take a decision, I don't think we'll have to spend some time.
Well, if your lordship will kindly have a look at the rules, my lord. The rules.
Not today. We are over time, so we'll fix it up some other time. There are some days, isn't it? You're retiring in October only. End of
October
October.
31st.
So we'll
But
just
my
have it-
preparation of pension papers takes some time. That's why, my lord, on the last occasion, it was observed that an attempt will be made to dispose of the matter finally. That's true, my lord. We are behind the clock.
If I sit, the rest, everyone stays back. I don't want to retain people like that. So it doesn't look good. So we'll have it some other time. This again. Since matter due to paucity of time, the matter could not be taken up today. The parties, the learned counsel for the petitioner otherwise expresses urgency in the matter, since the petitioner would be retiring by end of October 2025. In view of this matter.
Can it be on 15th?
Oh, 15th.
16th.
Why not 15?
15, my lord, Tuesday, usually, my lord, this will come up for.
Oh, I see. 1410 is good. Tuesday. Hearing day.
I had some, my lord, just immediately before after vacation.
Oh, you have some problem.
I have some problem.
All right. Like